And we've asked the accused to sit here because it's an application.
No, that's fine.
Effectively, yes.
No,
Thank
you
you.
know.
Thank you, my lord. My lord, we have indicated to your lordship the time allocation. I will start, and Mr. Masuku will cover two of the so-called pillars. I will deal with everything else at this stage. But, my lord, I thought even before we can do housekeeping matters, it might be important to start here, because this might assist in, or rather take care of what could otherwise have been a long argument. You'll remember, my lord, that we said in our heads that with the permission of the court, we would appraise the court as to what's happening with the other litigation. If I may then take the liberty to do so, my lord, because it may or may not be an issue here. The lordship will know that there was, on the 7th of June, a judgment in the preliminary litigation from the full court. Right. What then happened, my lord, is that on the 28th of July, there was then a hearing to do with the Section 18.3, which was brought by both accused in the private prosecution. That, my lord, in terms of Section 18.4, as your lordship knows, it's a subject of an automatic right of appeal. Yes. That appeal, my lord, was heard in the SCA on the 28th of September. And on the 13th of October, the judgment of the SCA was sent out. What has since happened is that as of 25th of October, which is yesterday, the application for leave to appeal in that matter was served. And I've just learnt now that I think because of the time, it was the stamp of the Constitutional Court says the 26th. But that case number in the Constitutional Court, my lord, is CCT 293/23. Right. So that's where matters are. And with the permission of my learned friends, I can make those statements from the bar. But if it's necessary, then we will hand up even just a copy of the notice. But I'm sure my learned friends were served with the papers, so they'll be able to confirm. So that's where we stand there, my lord. Now, we will deal with the implications of all of that, my lord, is a matter that has been raised by the other side, but which I will deal with in the argument. I just wanted to just situate where we are in relation to that. Right. Now, my lord, this particular matter before your lordship, as your lordship knows, was set down to be heard on the 15th of August, but for some reason it was postponed to today. And the parties have agreed, although it was set down for 2 days originally, that it can be disposed of in 1 day. And we will therefore endeavor to do that, my lord. And the reason for that, at least on our side, was because we realized that, as usual, even though we have 1,000 pages and all that the issues are actually quite narrow. The issue is very, very, very narrow, and we are therefore optimistic that we will be able to cover it in the space of 1 day. Lord, let me start here. Why this is probably one of the simplest matters that this court will have to deal with if one situates it properly. There is only one question that arises in this matter. Although, and I'll come to this, your lordship will see in the notice of motion that the relief is sought in two separate ways. There's a declarator and then the removal or recusal. It really, that's just a formalism. It doesn't matter whether the court takes the approach that says we declare that the conduct is unconstitutional and therefore give a Section 172 relief, just and equitable remedy, or the court takes the view that says this is just a simple recusal application, we'll look into the rules, the outcome will be the same. So, my Lord, there are three principal cases upon which we're going to rely. It's the case of Smith or Smythe. I never know how to pronounce this, but for present purposes, I'll call it Smythe. Yes. Smythe, and then there's the case. Mala?
S-M-Y-T-H-E.
M-Y, yes, that's why there's that confusion. Versus Ushe Okunze. And then, my Lord, there's the case of Van der Westhuizen. I'll give the citations, my Lord. They're in our heads. And then there's Porritt, of course. Porritt, which is our SCA case. We'll refer to other cases, but those are from the core of the argument. And, my Lord, I say that it's simple because whether it's under the rubric of the declarator, or whether it's the declarator, by the way, refers to the conduct of the state. Your Lordship will remember in our founding affidavit, we complain about the fact that the state itself failed to remove Advocate Downer upon our demand, and therefore, obviously, we then had to come to court. But the removal prayer, if you like, then deals directly with Mr. Downer's conduct, irrespective of whatever the state or the NPA did or did not do. Now, whichever eyes or glasses the court puts, my Lord, it boils down to this. It's literally, we just have to show the conduct that we are complaining of and juxtapose that against the expected conduct of a prosecutor. That's really, there's nothing more, nothing less than that. If we say, okay, this happened A, B, C, D, E, and then let's now measure it against the standards. If the standards, whatever A, B, C, D, E is matches the standard, then we cannot succeed. But if the standards that we're going to take the court through have not been met, then of course the court has no option. So that's the matter is as tight as that. And maybe, my Lord, to simplify it even further, I will be referring a lot to Smythe's case. I can say that the question is the same question. The first question that was asked in Smythe's case is really what's before this court. And in that case, it was articulated as follows. It said the issue is, number one, whether the applicant will be afforded a fair hearing in the event of the first respondent prosecuting the charges against him at the trial. That's really all there is to it. And this, my Lord, might also be an opportune moment to take care of one of the so-called points in limine that have been raised around res judicata and so on. And let me do that very quickly, my Lord. 3 so-called points in limine have been raised, and quite frankly, all of them have no merit, and they don't deserve to be dealt with in more than 5 minutes. The first one is so-called undue delay. Well, there's no question of undue delay because particularly in relation to what we call the trigger, which was the conduct of Mr. Downer in relation to the 2021 events. It's common cause that those events happened in August of 2021. Literally, in this very courtroom, in September, a month later, upon the instructions of the accused then, we indicated to Judge Kuhn, this is all common cause, indicated to Judge Kuhn that we hold instructions to lay charges in relation to that. Those charges were laid on the 21st of October, my Lord, of 2021. And so nobody can really, so that's when the law was set in motion in relation to what then eventually ended up being the private prosecution. Now there's a fallacy around this which is peddled by the other side, even not just in this litigation, where they say, oh, well, he waited for a year before the private prosecution was instituted in September of the following year. Now, at face value, that looks like it is so. But it loses the importance of the fact that the accused one could not have just done a private prosecution. He obviously had to lay charges, allow the NPA to investigate, get a nolle prosequi, and only then could he do that. So it's not like he was sitting doing nothing. So that's a very important issue, my lord. Then that's also important for another reason, which is this so-called res judicata issue. So there's no undue delay, and then there's another issue raised called stare decisis. Well, that you can just throw it out of the window. Stare decisis can never be a point in limine. Stare decisis is you have a case that proves something or it doesn't prove it, and then you raise it in argument. So the only thing we want to address up front, my lord, is the so-called res judicata. And I want to address it like this, so that we can quickly get to the merits. Your lordship would have had the benefit of reading Justice Kuhn's judgment in this court. And by the way, just to situate this, the reason why we are before your lordship is exactly because last year in October, we raised the fact that this application was going to be brought. And Justice Kuhn, because he had expressed certain views in his judgment, then suo motu, I think is the correct Latin, raised the issue of whether or not he can sit, and invited the parties to make representations. On the 30th of January this year, he then decided that he would recuse himself. Then your lordship entered, unfortunately or fortunately.
Am I not going to be faced with a similar situation?
No, fortunately your lordship has not expressed any views. But no, your lordship is not in that danger. But that's just for context. Now, and I want to say that I'll come back to that history for a different reason. I just want now to address specifically the so-called res judicata thing. Now, my lord, you will remember that I think it's at paragraph 120 of Justice Kuhn's judgment. He says specifically that, and we've put that in our founding affidavit. The lordship will find that at page 10. Sorry.
Right.
Thank you, my lord. Page 10, 10 of the papers, volume 1. Where we quote verbatim what Kuhn J said, which shows that there can never be an issue of res judicata or even issue estoppel here. And let me give context, because your lordship was not here when this happened.
So where exactly in his judgment does he make that remark?
That is paragraph 120, my lord, according to this. Let me just make sure that I'm correct. Paragraph 120 of the judgment.
Yes.
Yes, which in the bundle that was submitted by the other side, my lord, it's page 406
Yes.
of the, yes,
Yes.
all right. So, let me just give a bit of background, my lord. You'll remember that in the Section 106 matter, we attempted to say, let's kill two birds with one stone. Let's do the 106, but also deal with the issue of the removal of Mr. Downer. Justice Kuhn, for all the reasons that he explained, said, no, you can't do that. What is before me is a 106, 1H application to do with title to prosecute, not a removal on the basis of the fair trial rights. And he says, to make it clear, because when I suppose we wanted to sneak that second, prayer, he says at 120, the quote further alternative basis, which we wanted, contended for by Mr. Zuma, would presumably be a separate substantive application for the recusal or removal of Mr. Downer as one of the prosecutors. There is no such application before this court. The special plea in terms of Section 1061H of the CPA is the only issue. So that kills two birds with one stone. Firstly, there can't be res judicata because it was not before him. Remember, res judicata is just fancy Latin. It simply means the matter has been adjudicated.
Yes.
But so he could not adjudicate matter before him. But as my learned friends do, as we all do as lawyers, when you do res judicata, you also chuck in issue estoppel, just in case you are not good on the first one.
Yes.
So he deals with that as well. He says the special plea in terms of Section 1061H of the CPA is the only issue. So there's no issue estoppel and there's no res judicata. Despite our best attempts, as it were. So to come here and say, no, this matter has been adjudicated when Justice Kuhn makes it very clear that it was not even before him is just fanciful. So that, my lord, takes care of the so-called points in limine, all of them. So let's then come to the merits. And by the way, my lord, just so that I don't lose this point.
Just a moment, please.
I'm sorry. Yes.
Yes, thank you. You may proceed.
Yes, my lord. Just so that we don't lose this point. Porrit. Remember, the main reason why Justice Kuhn found against us in this matter, which was upheld all the way, was this crucial point, that in Porrit, the SCA had clearly drawn a line between a 1061H application and a removal based on fair trial rights. And all the courts agreed with Justice Kuhn on that. And that was because one of the reasons, I should say, now that the courts have determined it, is the following. These two things are not the same. And one of the clearest way, my lord, to illustrate that is let's look at the consequence. If in a 1061H application, the consequence in terms of Section 1064 is an acquittal, or maybe an acquittal, at least, in terms of 1064. So you can say, I'm pleading this, there's no title to prosecute, and I want an acquittal. You may or may not get it, that's not the issue for now. So a 1061H then is, if you like, it focuses on the prosecutor, but it can benefit the accused by way of an acquittal. Unlike this current situation, my lord, this current situation, and that's where the distinction was made in Porrit. In the current situation, if we succeed in our Section 35 objection, the outcome will not be an acquittal. outcome will simply be a replacement of Mr. Downer. So that's another clearest example of that these are two causes of action which might look similar to the naked eye, but actually have different legal outcomes and consequences and origins. So we can bury that and then come to the merits. Now, coming to the merits, my lord, let me start here. Your lordship is going to have to look at what we've called the cluster, the regulatory framework. The regulatory framework of what is expected from a prosecutor. And I take those words from Smythe's case. Because in Smythe, they say we have to look at the conduct of the prosecutor against what is expected. Now, that simple phrase, what is expected, encompasses a whole lot of things, my lord. It starts from the Constitution, it goes to legislation, it goes to the local guidelines, international guidelines, and the prosecution policy and code of the NPA. That is a body of what we call the regulatory framework against which the impugned conduct must be measured. So let's start there, my lord. The starting point should be Section 35, or should I say Section 30? Whenever I say Section 35 or 34, in this context, you read them interchangeably. Because in Smythe, it was established, and I don't think my learned friends will quibble with this, that actually the right to a fair hearing in Section 34 encompasses the right to an unbiased prosecutor. That seems like an obvious thing to say, but it's not obvious for the following reasons. Both Section 34 and 35, of course, your lordship will know that in Sheikh, it was said that in Section 35, that long list of things in Section 35.3, I think there are 15 things from A to O. But in Sheikh, it was said that that list is not exhaustive. The fair trial rights can be violated in many other ways, so one should not just look at that list here. So what was being said really both in Van der Vestes and in Smythe is that when you read Section 34, you can read in there that the right to an impartial prosecutor is incorporated. Similarly, when you read Section 35, the right to an impartial prosecutor is also incorporated. Why is that so? Because it was said in Smythe that, sorry a minute. It's at page 1134. It says, I have no difficulty in acknowledging the inherent danger of unfairness to the applicant attended upon the first respondent prosecuting at the trial. Hence, the question that arises is whether the applicant's right to a fair hearing, that's a Section 34 right, by an independent and impartial court established by law as enshrined in Section 18.2 there, that's equivalent of our Section 34, of the Constitution is likely, very important, likely to be contravened. To put the inquiry more pertinently, whether the words impartial court are to be construed so as to embrace a requirement that the prosecution exhibit fairness and impartiality in its treatment of the person charged with a criminal offense. In other words, what the learned Chief Justice was saying there was, when you read Section 34, that right there encompasses the requirement that a prosecutor must exhibit impartiality in the treatment of the accused. And just for completion, my lord, in van der Westhuizen, the SCA said the same thing differently as follows, at paragraph 9. It says, I pause to emphasize that the concept of impartiality in the South African Code, that's the Code of Prosecutors, the UN guidelines and the standards of International Association of Prosecutors is not used in the sense of not acting adversarially. Very important. I'll come to that in comparing the bias of judges and bias of prosecutors. But, said the SCA, in the sense of acting even-handedly, i.e. avoiding a discrimination, and, this is the important part, my lord, and the duty to act impartially is therefore part of the more general duty to act without fear, favor, or prejudice. So here now, the SCA was expanding the ambit. Remember in Smythe, it said that Section 34 encompasses the right. Now here, it takes it to Section 179 of the Constitution, 179.4 in particular. So 179.4, so these instruments must be looked at interchangeably, my lord. Section 34, Section 35, and Section 179.4 of the Constitution. So those are the constitutional prescripts. It's made clear by the courts. This is quite clear. Then, of course, we know that Section 1, that section is unpacked, quote unquote, in the NPA Act, particularly in Section 32. Because Section 32 of the NPA Act makes it clear that it specifically mentions the requirement of impartiality. Sorry, my lord. I know your lordship is familiar with this, but just at page 33, it's fine. Page 33 of the papers, my lord, we quote the section. And I do it only for emphasis. Section 32(1)(a), at paragraph 69. It says, a member of the prosecuting authority shall serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law. That's beautifully put because it encompasses everything I've said so far. It encompasses the right to a hearing. It encompasses Section 179, which is repeated here, 179.4. And then it says it also encompasses the whole Constitution, as it were, subject only to the Constitution and the law. In other words, any other provision of the law. So that's the second tier, my lord. Constitution, the Act, and then as far as what I call the third tier regulatory framework, you'll find, my lord, that these things speak to each other, obviously. Your lordship, if you go, your lordship, to page 29 of the papers. Right. We start at paragraph 22.6. I won't read it. That's the one, that the governing provision that says this applies to all prosecutors and must be complied with. The one I'm going to read, my lord, is 22, paragraph 59. It says this code acknowledges the crucial role of prosecutors in the administration of criminal justice. It emphasizes the essential need for prosecutions to be fair and effective, and for prosecutors to act without fear, favor, and prejudice. Again, a recount of Section 179.4. It says, furthermore, it serves to inform the public, very important, it serves to inform the public of what is expected of prosecutors. You remember, my lord, I just put a finger there. I referred to the wording in the Smythe case of what is expected of prosecutors by the public and by the law, as it were, and is aimed at ensuring public confidence in the integrity of the criminal justice process. Above all, this code requires all prosecutors to respect human dignity and human rights, and to perform their professional duties with the full recognition of the supremacy of the Constitution and the rule of law. And in that context, my Lord, we will be at pains, both myself and Mr. Masuku, to explain that that duty to respect the human dignity and human rights of Mr. Zuma in particular was breached in respect of the conduct that we're going to talk about. Then, my Lord, it says later, the NPA is committed to the highest ethical standards. This commitment guides every decision we make. In other words, when we wrote them a letter and we say to them, please remove this prosecutor because of this and that and the other, that decision itself should have been informed by the highest ethical standards. And we will persuade your Lordship with respect that the decision that was taken was not informed by the highest ethical standards, because one doesn't have to be a lawyer, my Lord, to understand that what we're dealing with here, that Mr. Downer could not, whether he's going to be found guilty or innocent or whatever in the actual prosecution is irrelevant. But for current purposes, he cannot be expected one should not even have to say this. He cannot be expected to be a prosecutor today and tomorrow to be the accused in the same matter, in the same courtroom, before the same judge. No how. It is just so self-evident. By adhering to those ethical standards, one is not admitting to anything, my Lord. And if I can make an example, my Lord, in case the other side doesn't know what ethical duty means, they must take a leaf from what Judge Kuhn did. Judge Kuhn, driven by his own ethical standards, said, I have made remarks. I cannot sit in the removal application. By saying that, my Lord, Judge Kuhn was not saying I'm biased, actually biased. No. Because I have no doubt about this. Judge Kuhn would have been quite capable as your Lordship, to hear this matter and give a fair decision. So he was not saying, no, I'm prejudiced. No, all he was saying is that, what will the public say if I have made remarks which say go this way, and then suddenly the following day I'm supposed to be neutral, and therefore I'm moving out from an ethical point of view. That's all that we're asking for, my Lord. We're not saying Mr. Downer must admit to any guilt of anything. We're not saying the NPA must paint him with a certain brush, but we're saying from an ethical, professional, ethical point of view, can you really, and I don't even want to go into what it means, my Lord, but simply what is called here, not just ethical standard, but the highest ethical standards that is expected from the NPA. And therefore, my Lord, we are saying two things should have happened. And this is important because when I come to the so-called nonsensical theory of Stalingrad, I will deal with this. Just postulate this, my Lord. If the NPA, or Mr. Downer for that matter, had done the right thing, and the right thing for both of them would have been to say, look, there are these complaints, we think that they are wrong. But the NPA would say, one, well, we're going to put another prosecutor. Or Mr. Downer, suo motu as well, would say, look, I can't, I'm moving out of my own accord, for following my own ethical stand, as we all would, my Lord. If I was doing a case, unsuspectingly against Mr. Masuku, and then somewhere in the middle of the case, it turns out that my client or the other side's client is somebody against whom I'm litigating somewhere else, who stole my car or knocked my car. I don't need anyone to come and make an application. The ethical duty should be for me to say, my Lord, I'm sorry, we've wasted your time for a week, but I've just, this has happened. This person beat up my sister or whatever it is. So I can no longer act with the necessary professional integrity and another advocate must take over. It's very simple. Now let's postulate that that had been done, which is really the right thing. If the NPA itself or Mr. Downer had done that, where would we be now? Because we're going to be told, well, there's going to be noise about Stalingrad and delays. This is what would have happened, my lord, if that had happened. On the 17th of October last year, which was the trial date that was set by Justice Kuhn, then we would have just all come here and said, my lord, we want to inform you that the other side, or the NPA, has withdrawn Mr. Downer, or Mr. Downer himself has withdrawn, and we're ready to call the first witness. That trial would have been finished now. It's now October again. It's a year later. And we're going to be told that that 1 year, which has been wasted purely by the intransigence of the other side, in the face of clear ethical duties on them, must be piled on the head of the accused, and it must be blamed on him. That's the kind of duplicity that we face. So much for the highest ethical standards. Then the last one, my lord, is at paragraph 61. It says, prosecutors should perform their duties without fear. Okay, we know that. A, they must carry out functions impartially and not become personally as opposed to professionally involved in any matter. And they must avoid taking decisions or involving themselves in matters where a conflict of interest exists or might exist. Not even a real conflict, or might exist. And take into consideration the public interest as distinct from the media or partisan interests and concerns, however vociferously these may be presented. So they must also blind themselves to media hype and media theories, rather than fueling them, because that's exactly what happened here. The reason why Mr. Zuma's medical information was leaked was not just for the sake of it. It was to fuel the media frenzy that, oh, here we go again, another, he's faking his illness, Stalingrad, and all that. So not only here where the prosecutors failed the duty to close their ears from media noise, they actually went to fuel it. And Mr. Downer was an active participant in that, as we will demonstrate. So, my lord, I can go on and on. Let me tighten the submission as follows. If you look at three standards, my lord, which are determined by the cases and what I've read out, we will rely, there are many things that have been breached here, but we'll rely on the following three. Any one of them will be sufficient. The duty to be dispassionate, sometimes expressed as detachment. And I'll show you, Lordship, where to find that. The duty to be impartial. I've already demonstrated that to your Lordship. And the duty to be ethical. I've also touched on that. Just those three. Any breach of any one of those three would be sufficient to disqualify a prosecutor. Now, sorry, my lord. If your Lordship will find the first one, which is the issue of detachment. You'll find that, my lord, at in Smythe, at page 1130. So it is specifically alleged that the first respondent, it is specifically alleged against the first respondent, that's the prosecutor, that he has involved himself in a personal crusade against the applicant and that he lacks the objectivity, detachment, and impartiality necessary to ensure that the state's case is presented fairly. It is further said that the first respondent has exhibited bias against the applicant. And here's the crux, my lord. Before considering the particular features of the first respondent's conduct, upon which reliance is placed, it is well to outline what society expects of a prosecutor. So that's the juxtaposition I said earlier, my lord, that the job of the court is very easy. Weigh the conduct, alleged conduct, against the expectations. So that's the detachment requirement, if you like. That same, sorry, my lord. In Van der Westhuizen, in the same breath, my lord, the SCA had this to say about the duty to be dispassionate. It quoted some cases, some foreign cases. In the initial remarks of Rand J. in Boucher, I'm sorry, I'm reading at paragraph 11, my lord. In the passage quoted above must not, however, be misunderstood. In our practice, it is not the function of a prosecutor disinterestedly to place a hodgepodge of contradictory evidence before a court and then leave the court to make of it what it wills. We concede that. But here's the issue. It says, on the contrary, it is the obligation of a prosecutor firmly, but, and these the words that come after but are important, firmly but fairly and dispassionately to construct and present a case from what appears to be credible evidence and to challenge the evidence of the accused and so on. So in Van der Westhuizen, that qualification is important. My lord, we're not, well, even if we were naive, there would be no room for it because the SCA has made this very clear. The SCA, you'll remember, my lord, one of the, actually the question of law that was placed before the SCA in Porritt was whether the court accord had applied the correct standard, the SARFU standard, let's call it that, in disqualifying a prosecutor. In other words, to put it simplistically, is the test for the removal of a prosecutor the same as the removal of a judge? Yes. My lord, we have made it clear in the papers and in the heads so that nobody must accuse us. We concede upfront that there is a difference between the recusal of a judge and the recusal of a prosecutor. But that must not be used to then mean that the prosecutor can do whatever they like.
Sorry, just a moment, please.
I'm sorry, my lord. Because that is a lordship ready?
Just a minute, please.
Okay, my lord.
Yes, thank you. You may proceed.
Yes, my lord. So the qualification or the caveat given in Van der Westhuizen is very important. Family, yes, of course, you must bet for your side and what have you, but fairly and dispassionately. And my lord, we will demonstrate, Mr. Masuku will deal with that section, but we'll demonstrate that just one example, which is common cause, that Mr. Downer, on his own version, upon being told that the charges were withdrawn, he says he cried, he was reduced to tears. These are his own words, in his own affidavit, not mine. Reduced to tears. Now, can that ever be, can that ever pass the test of detachment and being dispassionate? My lord, however, that's our duty. If I could have my client here, everyone could take him and drag him onto the ground or whatever. But the minute I now take it personally and myself break down here before your lordship, then your lordship will start thinking there's something wrong. It looks like this is more than just a professional duty now. It's something else.
I'll give you a moment to compose yourself.
I know, my lord, and a glass of water. So, but my lord, on a serious note, I'm saying just that, and my lord, please note this. you'll hear this from me many times, on the admitted facts. Those words you're going to hear from me many times. So we want to make the job of the court very easy. If anything is disputed, we'll leave it away, my lord. We're going to ask this court to consider this matter on the admitted facts. So if we say Mr. Downer cried, and he says, no, I laughed, then we will leave that alone. But if, as it says here, he says himself that he cried, then we want your lordship to consider that, because those are the admitted facts. That will make the life of this court very easy. So we will give to them anything that they say, no, it didn't happen this way or whatever, truthfully, unless where we can show that the objective evidence is points otherwise. And again, let me make an example. Mr. Masuku will deal with it again, just to give one example. Mr. Downer, when I say we'll accept everything they dispute, I don't mean we'll accept even things that are clearly, objectively false. So I'll give you an example, my lord. Mr. Downer says, in relation to the Mr. Soul incident, your lordship knows that. He says, well, I was authorized to speak to Mr. Soul. And in other words, I was just doing my job. Well, my lord, Mr. Masuku will show you that is the furthest thing from the truth, just on the objective evidence. Because he says himself, not us, in that exchange, please don't quote me, because they will know that it's me who's talking to you. Now, who does that? If he was really doing his job as like any other prosecutor, why would he say to the person, don't tell them that it's me, or don't put it this way, don't put it that way, and so on? The truth, my lord, is that, we're just being made to look like children here. The truth is that Mr. Downer, when he leaked that information to Mr. Soul, did not know that one day there will be so-called spy tapes which would blow his cover, so to speak. And that's why he was using words like the F word, and in that exchange they used the F word and the S word and so on. A spokesperson of the NPA would not speak like that. He was doing that because they thought that they were doing it in the cover of darkness until they were discovered. So there's a limit to what we can concede. So blatant things like that we will contest. But by and large, my lord, we will implore this court to deal with this matter on what we call the admitted facts. So that's the dispassionate requirement. The other two I've already covered, my lord, the impartiality and ethicality. And at the risk of repetition, my lord, anyone, if your lordship finds just that he is not sufficiently dispassionate, not sufficiently impartial, or not sufficiently ethical, your lordship will be entitled to grant the relief. But here's the thing, my lord, with the greatest respect, which is also important. There are 3 levels against which your lordship must measure this conduct. Your lordship must ask yourself the following 3 questions. 1, does this conduct exhibit that Mr. Downer is actually biased? If your lordship finds that he cannot find on that basis, then your lordship will have to ask the second question. Does this conduct induce the reasonable apprehension on the part of Mr. Zuma that he will not receive a fair trial? And if your lordship finds against us on that, even that secondary question, then your lordship will have to ask the third question. Is there a risk of an impartial, of an unfair trial in this conduct? Again, one answer, yes, to all of those 3 is sufficient for us, my lord. Why do I say that? And I'm saying this because there's some suggestion in the heads of the other side, the Lordship would have seen this, that a reasonable apprehension doesn't apply. It only applies to judges. Nothing could be further from the truth. That was clarified in Porritt and in all the other cases. But here, my Lord, is where it was made clear by... I've already read this, but it was for a different reason. Go by CJ at page 1132 of Smythe. Let me do this, my Lord, because it also covers this issue about denials and so on. The reason why, my Lord, we say with respect this is a simple case is because it's one of those cases, if it was an RAF case, we would say it's one of those cases of res ipsa loquitur. The conduct speaks for itself, my Lord. And I'll show why that's important. This is what was said in Smythe as well. Okay, all right. So the judge then, the Chief Justice spoke about the test and the English cases and what have you. And then he says, expectedly, sorry, I'm reading at 1131. Expectedly, and this is true, it is denied by the first respondent, that is by Mr. Downer, that he has lost objectivity in relation to the applicant and that it is his wish to harass and embarrass him. Let me just pause there. Expectedly, it will be denied by Mr. Downer that when they were doing those shenanigans with Ms. Karen Mon, the idea was to embarrass Mr. Zuma and to splash out his medical information without the permission of the NDPP. And then the court said, yet the undisputed facts speak for themselves. The undisputed facts, not the contested facts. And it says, regrettably, they reveal that the first respondent's behavior has fallen short of the customary standards of fairness and detachment demanded of a prosecutor. And here's the important part, my Lord, in terms of the test. It says, they instill a belief, in other words, a belief in Mr. Zuma. That conduct instills a belief that if the case were to remain in his hands, in Mr. Downer's hands, there is, at the very least, a real risk that he will not conduct the trial with due regard to the basic rights and dignity of Mr. Zuma. And then I draw the attention to the occurrences which have been held, which we will deal with now. What does this really say, my Lord? It captures really the entire three-stage test that I've postulated. So it says it might be that the conduct is clearly biased. Let's say he just went outside and said, yeah, I'm going to get that Zuma, and he'll never get a fair trial, whatever. Then it's actual bias, that's obvious. But the court is saying, no, it's more than that. Firstly, does the conduct instill a belief in the accused person that he's going to get a trial? And in the public, we've already spoken about the public. Public must say, as I say, the public must say, okay, on Monday, Mr. Zuma is the prosecutor, Mr. Downer is the accused. On Tuesday, it's the other way around. Does that instill a belief that the justice system is functioning? Or, says the court, at the very least, a real risk that he will not conduct the trial properly. Now, surely, my Lord, on any one of those three tests, we have met those tests. Because it might be that Mr. Downer is the most angelic human being. And when he is prosecuting, he will disabuse himself of anything that's happening in the private prosecutor. Maybe he is. But is there a real risk that he will not do that? There is. Because nobody can ever say that, I mean, however holy we are, you can't say, well, the same person who was cross-examining me yesterday and calling me this and that, and then the following day, I'm supposed to assume that he is. What does that do to the administration of justice? This is not a banana republic where we can just have a free-for-all. Surely, some of the rights that are imbued on Mr. Zuma by the Constitution, like all of us, one of those is that he must be prosecuted by a person who meets the standards set out here. Surely. And it's not personal. Just as Mr. Zuma said to Justice Kuhn, I believe that you should recuse yourself because I will not, you may be able to disabuse yourself of the remarks you made, but I don't believe that. My apprehension is that you won't. And Justice Kuhn, well, I can't even say Justice Kuhn obliged. He himself had raised that point without any one of us. So we can't even take credit for that. And he rightly did so. So, my Lord, we then come to the I've now mapped out, my Lord, what I call the body of standards, of expectations. I've explained to Your Lordship the test, what I call the three-tier test. So I will now go to the conduct. So what is it then that we are complaining about? Well, my Lord, in this respect, we deal with the so-called 4 pillars. I will deal with 2, and Mr. Masuku will deal with the other 2. Remember now, my Lord, we're not talking so much about the declarator. The declarator is very simple. We're saying the state or the NPA ought to have, on its own accord, granted us the decision that we wanted. They failed to do so, and Your Lordship will just have to say, that conduct, is it in line or is it consistent or inconsistent with our Constitution? If it is not, then Your Lordship will grant the declarator, and then Your Lordship will deal with the Section 172 consequences thereof. We're now dealing with, I think it's prayer 3, which is the recusal proper. We premise it on the basis of the 4
Pillars.
Pillars, yes. And I've already, in a way, indirectly covered the first one.
Covered the first one.
Yes. So I'll just spend 1 minute on the first one because I want to go to pillar number 2, which is the actual conduct. On the first one, my Lord, our submission is very simple. We are saying, at the risk of repetition, for the purposes of pillar 1, put aside the guilt, otherwise, or whatever of Mr. Downer. We're simply saying the aesthetics of the situation. The mere fact that he is an accused in the one case and
prosecutor in another.
Yes, and the prosecutor in the other, my Lord. And let me preempt this, my Lord, if Your Lordship allows me, again, kill 2 birds with 1 stone. You're going to hear, my Lord, that, oh, well, the full court said that the private prosecution is an abuse of process, what have you, Stalingrad, and the SCA also said. So let me just kill that quickly. Firstly, my Lord, Your Lordship knows that merely by the, or rather that the judgment of the SCA is, by operation of law, suspended as we speak, purely because of the operation of Section 18(1) of the SCA, which says that if a decision has been appealed against, it is suspended. We know, my Lord, it's trite law that means that judgment is inoperational and ineffective. By the way, that's the only reason why they did a Section 18 application, is because they knew the implications of our application for leave to appeal in this court. And within their rights, then they exercise their rights in terms of Section 18(3). But the fallacy seems to be this, my Lord. that some people think that that section 18.1 only applies to the lower court appeals, so to speak. But that section is not qualified. It simply says if a decision is on appeal, a subject of an appeal, or an application for leave to appeal, it's suspended. Where that appeal is irrelevant, whether it's in the Crown Court or the High Court or the full court or whatever it is. So that's the one issue. But my Lord, in the unlikely event that they can place any reliance on either that judgment of the High Court or the judgment of the SCA, that judgment itself actually works against them, my Lord. Your Lordship would have received the latest documents from the other side where they put two cases.
Yes.
Yes. One of those cases, my Lord, is the SCA decision.
Right.
Of Pananji J.A. I think I have an extra copy, my Lord.
I mean, the SA decision of the full court,
No, my Lord, the SCA one.
right?
In the
Which
front, my Lord, it will say Koram Mulimela P.
Yes.
Is your Lordship got that?
Yes, I've got
Yes,
that
thank you, my Lord. Okay, thank you. Okay, thank you very much.
Yeah.
Now, my Lord, go to paragraph 21 of that judgment.
Yes.
Even the SCA says the following. And this was in the context, my Lord, of whether or not there's any irreparable harm on the part of Mr. Zuma. So in answering that question, presumably against us, then the following was said. There seemed to be an acceptance that if the appeal against the main judgment will ultimately succeed either before this court or the Constitutional Court, then Mr. Zuma could simply pick up the private prosecution. But that's not my quibble for now. The effect of the execution order is that the private prosecution has been placed on hold pending Mr. Zuma's attempt at an appeal. The only conceivable adverse consequence of the execution order on Mr. Zuma is that his private prosecution will be delayed until finalization of the appeal process. The private prosecution is plainly not urgent. Indeed, Mr. Zuma instituted the prosecution over a year after publication of the doctor's note. I've already said that that's just wrong, but let's put that on the side. Now, it says, there is no cognizable harm to Mr. Zuma. Now, here's the important part. It says, he will suffer no harm because the respondents remain under threat of prosecution until such time as Mr. Zuma's appeals are exhausted. Let me repeat that. He will suffer no harm because the respondents remain under threat of prosecution until such time as Mr. Zuma's appeals are exhausted. If Mr. Zuma is successful in the appeals, he can simply resume the private prosecution. Now, for the purposes of this court, my Lord, that is fatal to the state, because it means that even the SCA acknowledges that Mr. Downer is still living under the threat of the prosecution. Let's assume we had not even appealed in the Constitutional Court. That, for the purposes of this case, my Lord, that is sufficient. As we said, we don't have to show that Mr. Downer is going to be convicted, or that he might not even pass Section 174 or whatever it is. The mere fact that he is, as we speak, as we're sitting here, and tomorrow, and next week, and next month, he will be under the threat of the prosecution by Mr. Zuma is sufficient to disqualify him as a prosecutor in his case. So, firstly, we say it's suspended, but even if it were to be used, actually, if the law was different, we would unsuspend it because it assists us. So, on either leg, remember, my Lord, that the reason why the threat is sufficient is because what we're after is not actual bias as such, it's the risk thereof and the apprehension. Yeah. So the question can be posed like this. Can Mr. Downer, who is under the threat of prosecution until, as Ponant J.A. says, until the end of the appeals, even to the Constitutional Court, now be allowed to prosecute Mr. Zuma? The answer is clearly no. Now, the conduct. So let me just check my time. I don't want to take all of Mr. Masuku's time. Right, okay.
I think he's only left with 45 minutes.
Yes. Thank you, my Lord. Now, maybe I should just check if Your Lordship going to take the break at 1:30.
Let's proceed.
Okay, fine.
If it's in order, if it's fine with everyone else,
Until,
I'm okay.
yes.
Can we proceed, gentlemen, ladies? Is it okay?
Thank you, my Lord.
Yes,
And
thank you.
to my Lord, friends. Thank you, my Lord, and to Your Lordship. The conduct, my Lord, is simply. I'm done with Pillar 1,
Yes.
on the basis that the mere prosecution is sufficient, and also that so every time in their heads, my Lord, where they say the full court said this, the full court said that, I've literally, and I hope Your Lordship will do the same. Every time I read that in their heads, I just scratch it off, because it doesn't matter what the full court said or not. That judgment is suspended. Pillar 2. Sorry. Oh, my Lord, I don't think, Your Lordship, I don't think it's necessary. I've just been given a copy of the face of the Concord appeal,
No, it's
but
fine.
I don't think my learned friends will contest that. Thank you. So, my Lord, in terms of Pillar 2, we now turn the tables, as it were. Having said in Pillar 1, don't worry about the conduct and the merits thereof, we now do the exact opposite. We now say, worry about the conduct. Because we're saying that in Pillar 2, let's just look at what Mr. Downer is accused of. I won't put it higher than that. And again, my Lord, with the greatest respect, I will implore the court to look at the version of the state. So, my Lord, this is what happens on everybody's version. It's the 8th of August, 2021. And I'm not testifying from the bar, but at least to the extent that I was involved, this is what actually happened, my Lord. On that date, former President Zuma was sitting in a hospital bed, on a hospital bed in Pretoria. This is during his incarceration at the escort facility. I went to see him there, and
Lord, I don't want to interrupt. My learned friend really shouldn't be
Yes, yeah.
okay.
I'll be a witness in this case.
I agree, Mr.
Yeah,
Mr.
that's
Mpofu.
fine. That's fine, my Lord. It's okay. Let me say what is in the. By the way, all this is in the affidavits which they have admitted, but that's fine. It is. It is. I'll find it for you. It says Mr. Mpofu. It's on page. Okay, we'll find it now. But my Lord, I don't want to waste time on non-important thing. That day, there was an exchange between myself. If Mr. Trengove, whom Mr. Badlander has replaced, was here, he wouldn't be jumping up and down because he knows we had this discussion, me and him, and it's in the papers. We then say to Mr. Trenkov, Mr. Trenkov, I've just become, it's a courtesy as a colleague, just become aware that there is this letter, and we were supposed to come here on the 10th, my lord. And therefore, there's a possibility of postponement. Mr. Trenkov says, okay, I'll speak to Mr. Downer. He speaks to Mr. Downer. Mr. Downer writes me a letter, I think that same evening. Yes. And says, it's fine, we won't oppose the postponement. Yes. But you have to apply for it. Fair enough, again, this is collegiality 101. The following day, my lord, is a public holiday. Just so happens, it's Women's Day. Then Justice Kuhn issues a directive. He says, you must do the application, and if it's opposed on the next date, then you must get the doctors to come to court. But for the purposes of this application, you just need a confirmatory from the doctor. Right. Again, fair enough. Then on the 9th, this is common cause. At 11:46, Mr. Downer attests to an affidavit which is unsolicited, quite frankly, because there was no reason for that affidavit. According to Mr. Zuma, it was just a ruse to leak his medical documents. Because remember, Justice Kuhn has asked us to apply, not them. So I've never heard of a situation where the respondent actually does an affidavit when the applicant is asking for a postponement. But let's put that aside. At 11:46, he does that unsigned affidavit. My lord, at 16:43, Mr. Breitenbach, who is Mr. Downer's colleague, says, of his own accord, again, there's another fallacy, because we were told about media request. There was no media request. Mr. Breitenbach, unprovoked, picks up the phone, sends a message to Ms. Karen Mon to say, and he gives some story. He says he had heard somewhere that on Twitter she had COVID and what have you. And anyone who believes that will believe anything. But even if you believe it, then why was that information then not given to the whole media? To say, please don't go to Maritzburg because there's an agreed postponement. Anyway, let's leave those. Those will be explored in the private prosecution. So he then, out of the blue, phones Ms. Mon to say, there's going to, where are you? Or whatever. She says, no, I'm already here. And your lordship will find that at, page 502. That will be volume 6. Again, we don't know what the discussion was before this. That will come out in the private prosecution or under cross-examination. But here, the one that were given by Mr. Downer himself says, I hope you are well and aren't en route to PMB. This is 1639. Ms. Mon responds, I'm here. At 1644, Mr. Breitenbach sends Kuhn J letter. That's it. And then at 1646, he sends Zuma postponement affidavit. That alone, by the way, meets the standards, all the standards of what we've just said, because it is said that they should not communicate with the media except or give any information except with the permission of the NDPP. But let's put that aside. Then at 6, okay, this is now on the 9th. I'm simply showing, my Lord, that there's no question of Ms. Mon or some media inquiry or whatever. So what then happens is, Mr. Breitenbach, then says, okay, I'm giving you this information, and here's the important part, my Lord. I call this the deal. He says, I'm giving you this information, but don't publish it until the documents are filed tomorrow. Mark those words. Don't publish it until the documents are filed. And here's the fallacy. And again, it's deliberate, I think. We're always told about the publication of the document. But Section 41.6 has got nothing to do with publication, my Lord. It's disclosure. So whether Ms. Mon published the thing or put it under the mattress or bent it in the oven or whatever, it's irrelevant. It's the disclosure. The crime is in the disclosure of the information. So what was really happening? The information was disclosed to the knowledge of the prosecution without it being filed in court. Because if it wasn't so, they would not have done the deal. They wouldn't have said, don't publish this until we file it. That's what is called in criminal law, knowledge of unlawfulness, mens rea. You know that what you're doing is wrong. So that's the giveaway. Because you don't do the deal. If you think, as they now pretend, they lie even to this court, because they now say under oath, no, the document was filed. But that's a lie. How can, if it was filed in court, as you say, then why did you say, don't publish it until it's filed? According to you, it was already filed. So you could never have said that, because you believed that it was filed and the Sandral case applies and all that. And then Mr. Breitenbach, then this is where Mr. Downer gets involved. Then says to Mr. Downer, this is Mr. Downer's version, by the way, my Lord. He says, I was told by Mr. Breitenbach that he has done this, and he has done this deal, and I must inform him, therefore, when the thing has been filed. This is common cause. Well, in criminal law, we call that a confession, my Lord. Because what he's saying, remember what we're complaining of, my Lord. Very important, and I'll find the ethical rule. One of the ethical rules, my Lord, is if one of your colleagues is doing something wrong in the prosecution, you must report it to the highest authority. I'll find it, my Lord. But that's right. So the actus reus in the part of Mr. Downer is not all these things that obfuscation. It is his failure. If Mr. Masuku comes to me here, my Lord, and says, hey, you know, during the tea break, I just took a bribe, you know, and he says he did. Thank you. Okay, thank you. It's page 31, my Lord, where that rule is. Thank you, Mr. Simpson. At paragraph 63 of our sentence. All prosecutors should respect and comply with the terms of this code and report any instances, page 31, paragraph 63, sorry, my Lord. Any instances of unprofessional conduct by colleagues, including Mr. Masuku, and also, as the case may be, other court officials, to the relevant supervising authority, who should consider the appropriate steps to be taken and do so. So that's what I was just, thank you, making that example. If Mr. Masuku takes a bribe outside here in the passage, my Lord, and tells me, forget about Mr. Masuku, whatever will happen to him. if I keep quiet and don't report him to the Bar Council, then I am guilty of breaching that ethical rule. It might be that later on, Mr. Masuku, maybe he was making it up or he was joking. This person was just paying back his money or whatever. And therefore, Mr. Masuku will be found not guilty of taking the bribe because someone else was paying him his own money. But I am not off the hook simply because he's innocent. I will be found guilty of failing, A, to stop him, and B, to report him. That's really the crux of this case. Everybody pretends not to understand that, but it's actually that simple. And therefore, the crime was committed on the 9th, not on the 10th. On the 9th, when, upon being told Mr. Downer did nothing. We all know Criminal Law 101. You can commit a crime by omission or commission. And we say, so he says, when we say, well, that means then you sanctioned or authorized what Mr. Breitenbach is doing. He says, no, I never sanctioned it. As if we're children, as if what we mean is that you said, Mr. Breitenbach, please give this thing to Ms. Mon. No, that's not what we're saying. We're saying he sanctioned it by his inaction as the lead prosecutor, by the doing nothing in the face of a clear illegality, a breach of Section 41(6) of the NPA Act in front of him. And what makes it worse, my lord, you can even excuse Mr. Breitenbach because he might say, look, I'm just a member of the bar. I was just asked to do this case. He's in the same position as Mr. Badlander. But we're talking about Mr. Downer here. Mr. Downer is a seasoned member of the NPA. He cannot say, I've never read the NPA Act. I don't know about Section 41(6). More than that, he says in his own affidavit, this problem of leaking to the media is a prevalent problem which was identified in the Gampepe Commission, and I condemned it myself, Mr. Downer. So that person who condemned this is now being told by a colleague that I've just done that which you've condemned. And he does nothing. He doesn't say, what? What did you do? This is exactly what Justice Gampepe warned us about. I'm going to act in terms of that. That's the issue, madam. So, Your Lordship, if you go to page 371. No, sorry, let's start at 372, volume 4.
Yes.
74.1 says here. It says the account of Ms. Mon and Mr. Breitenbach. In other words, this is the other side, not us. At about 16:45 on Monday, 9 August, Ms. Mon asked Mr. Breitenbach for a copy of the unsigned affidavit sent to Ms. Justice Kuhn earlier that day. Well, that's not true. We know that Ms. Mon, the thing was initiated by Mr. Breitenbach, but that's not important for now. It says Mr. Breitenbach sent a copy on condition that she would not publish anything based on the affidavit before the signed copy was filed at court. Underline that, filed. So that was the deal. And then at 74.2, says later that afternoon, this is where now Mr. Downer comes in. Mr. Breitenbach told me of his arrangement with Ms. Mon and inquired when I proposed to file my signed affidavit. I told him that I proposed to do so first thing the following morning. These are the people who lie under oath and say that the document was already filed. But here they say again under oath, I told him I'll only file tomorrow. Juxtapose that, my lord, with paragraph 70, which is that on the previous page. The same Mr. Downer, with a straight face under oath, says, it follows that both parties filed General Ducha's letter on public record on 9 August 2021. I did so in the morning at 11:46, and Mr. Tusini did so that evening at 21:07. That's a blue lie, to his knowledge. He could not have filed it at 11:46, and Mr. Tusini did so in the evening. When he says, in the very next page, I told him I'm going to file it tomorrow. So that alone, my lord, is if someone is brazen enough to lie to this court, how is Mr. Downer, Mr. Zuma supposed to think that that person is going to conduct themselves professionally during the prosecution? That's just a simple lie. You can't say, I say I filed it at 11:46, and then in the same breath you say, I told him I'm going to do it the following day. So that's where the conduct is wrong, my lord. Now, put yourself, my lord, then in the shoes of Mr. Zuma to say, here's a person, he's a prosecutor, he's under a professional duty to at least report his colleague, minimum. He fails to do so. Not only does he fail to do so, he actively assists in the commission of the crime. Not simply by his silence, but by the agreement that I will let you know. In other words, he's aiding and abetting the commission of the crime. I'll let you know when I've filed. And we all know, my lord, what then happened. The following day, indeed, Mr. Breitenbach called Ms. Mon to say, I'll speak to Billy, and then, sorry, my lord. I forgot that page now. It was 502. At 503, my lord, you'll see, says, when can I publish this? This is now in the morning. Here's another sign of knowledge of unlawfulness. This is now after Mr. Breitenbach had sent Mr. Tusini's affidavit. She says, when can I publish this? He says, it was emailed to the judge's registrar and the parties last night, so you can do so now. Which is good. In other words, they know that because Mr. Tusini's affidavit was emailed to the judge, I mean, this was wrong, by the way, because it had not yet been filed, but put that aside. But they say you can publish it now because it has already been filed, as it were. That's what they're saying. She says, great. And then she says, I need to wait before I filing the story, she means. On Billy, though, that means I must wait for Mr. Downer. And then Mr. Breitenbach, I'll check with him, please, otherwise it's just their side. And he says, and Tusini refers to Billy's affidavit. Okay? Now, this has two implications. One is that they know that they're doing something wrong. Two is that there can be no mistake about when the document was filed. And my lord, just for the sake to complete that point, if I refer your lordship to page 125. No, sorry, my lord. Let's go to 484. Just in trying to shortcut this. 484, that will be volume 5, my lord. Just to show you the kind of thing that the courts are expected to tolerate. You know, in any criminal case, they say there's always the smoking gun. This is the smoking gun. Page 484. It's an email, my lord, sent by none other than Mr. Downer himself to Ms. Griffin, the registrar of Justice Kuhn. Mind you, what he said at that paragraph 70, where he said the thing was already filed. It says, I indicated in my email that I would send my affidavit once it was made and so on, due to the public holiday and what have you. The important part is the last sentence, madam. As soon as we have had them commissioned, tomorrow, underline tomorrow, we will file them with you at court. as soon as we have them commissioned tomorrow, the date of the email is the 9th of August at 11:46. So he knows at that stage, he says, we will file, as soon as we have commissioned them, we will file them tomorrow. And yet, he says under oath, it was that which he said was going to be done tomorrow had already been done on the 9th. And by the way, even Mr. Tusini, just for the sake of completion, understood that the actual filing will only happen the following day. If you go to page 707, you'll see Mr. Tusini writes a letter to the same Ms. Griffin. And he says, dear sirs, herewith is the first accused notice of application. This is now in the evening. For condonation, BM Tusini's affidavit and its annexed charge, as well as that of Brigadier MZ Mducha, for your attention. Our correspondent will file the same tomorrow at court. So everyone knew that the filing is going to happen tomorrow. But now we're told under oath the exact opposite, but that both parties had actually filed on the 9th. Pure obfuscation. That kind of thing won't even withstand 1 minute under cross-examination. That's why they want to avoid the private prosecution. So, my Lord, with the greatest respect, the conduct, the admitted conduct, and I say that again advisedly, the admitted conduct on the papers, the objective evidence based on what they say themselves, what they've written themselves, the emails that they've written, forget about anything we're accusing them of, shows that this is a person who's A, capable of lying to this court, B, of having failed in his ethical duty to report the transgression or the apparent transgression and leaking of documents, and C, of having actively participated in that, and D, which is most important, in that whole scheme, who is the victim? Mr. Zuma. Because I've said this to many courts, you know, let's forget the legalese and the technicalities. I want anybody who would like their medical information to be bandied about here, whether it's me or you or anyone here, to raise their hand and say, no, me, I don't, you can just give away my medical record, or whatever it contains. So, and that is why, my Lord, we rely on the I'm sorry. That's why we rely on the. Right. We rely on the foreign case of which you'll find at paragraph 108. Of our heads, my Lord. Because, you know, it's all very well, we can talk about all these technicalities, but there are human rights of a particular person here that are being affected. And this is what the European courts had to say about it. In the case of Alvig, Kenya, and others versus Russia, 2014-35 BHRC. The protection of personal data, including medical information, is of fundamental importance to a person's enjoyment of the rights to respect of his or her private and family life, guaranteed by Article 8 of the Convention. Respecting the confidentiality of health data is a vital principle in the legal systems of all the contracting parties to the Convention. The disclosure of such data may seriously affect a person's private and family life, as well as their social and employment situation, by exposing them to the opprobrium and the risk of ostracism. And then says, the collection by the prosecutor's office of confidential medical information concerning the applicants was not accompanied by sufficient safeguards to prevent disclosure inconsistent with the respect of the applicant's private life guaranteed under Article 8 of the Convention. I need not even say that Article 8 is exactly the same as our privacy rights and the health rights and so on. So in everything that I've said, let's not forget that what was being done was to assault and violate and infringe upon the rights by prosecutor, not by some other person walking around the street, by a prosecutor, by the state itself of the fundamental rights. And then he's expected to believe that such a person will be neutral. So, my Lord, on the basis of just those first two pillars, we implore your Lordship to find that the prayers, either 1, 2, or 3, or both, have been satisfied. Lord, if I may then ask Mr. Masuku to take it from where I've left off. Yes. He'll use the same examples, but, or rather, the same framework, but now using the soul. The soul. Yes. Thank you. As God pleases. I mean, that's
Thank you. Yes, Mr. Masuku has very little time left.
No, I do, my Lord, and it's fair, Mr. Boff, we had to deal with more than I have to deal with, but
yes.
just so I'm able to put to add to what Mr. Boff has said.
Yes.
May I start off by referring to your Lordship, and my submission is going to be based on 3 principles. The first principle is set out in the judgment of the Zuma versus the spy tapes, if you want to
yes.
It's Zuma versus the DA's 2018 Volume 1 SA 200, and it's on paragraph 91. In that paragraph, my Lord, the Supreme Court of Appeal says, it mentions refers to a very tried principle, which is the following. It is incumbent on prosecutors to disclose to a court any fact which, in their view, may impact negatively on the prosecution and in favor of the accused. This is in line with constitutional values and provisions of the NPA Act. It is in the interest of the NPA, accused persons, the public's confidence in the administration of justice, that decisions concerning allegations of abuse of process be made by a trial court. You will set, my Lord, you will search and find that the new narrative on why we are here today and why Mr. Zuma has endured 20 years, over 20 years, of humiliating uncertainty insofar as the prosecution is concerned. You'll find you'll find that in the affidavits of Mr. Downer, that Mr. Zuma is to blame. Now, what is an impartial prosecutor doing? Labeling an accused person who is genuinely fighting for the rights that they have insofar as a fair trial right is concerned. What is an impartial prosecutor doing? Labeling that accused person a Stalin grandist, a person who is trying to avoid a criminal trial, and by insinuating that he's trying to avoid his trial, he suggests that Mr. Zuma should absolutely not quibble about what has been set out in the judgment of the Supreme Court of Appeal, in that judgment I've referred to your Lordship to. I would urge your Lordship to go through the judgment and find what the Supreme Court of Appeal says about the conduct of the NPA. You'll find that the conduct of the NPA is nothing short of criminal conduct, which Mr. Downer has successfully managed through a reinterpretation of facts to say that 20 years of that delay must be placed on Mr. Zuma. Sure. It's a very easy exercise to do, my Lord, to find how Mr. Downer has pegged the entire reason for the delay on Mr. Zuma. It is not fair for a prosecutor who is supposed to be impartial to conduct themselves that way, that they should continue to label someone they are going to prosecute, the kind of labeling that and the insults, not just labeling, it's insult. When you say you are trying to avoid a trial, so you are adopting frivolous strategies in order to avoid a criminal trial. And they go as far as gloating about the successes they enjoy in the Supreme Court of Appeal, particularly on these matters. You will find, my Lord, when you read through the affidavits of Mr. Downer, when he deals with what he calls Stalingrad, the Stalingrad strategy, it starts on page 534, that he studiously avoids mentioning key decisions made by the NPA. Studiously avoids doing that. He avoids mentioning the fact that the decision not to prosecute Mr. Zuma was the NPA's decision. It was not Mr. Zuma's decision.
Sorry, just you mean earlier decisions not to
The
prosecute
earlier Mr. Nguga's decision where he said there's no winnable case against Mr. Zuma. It was the NPA's decision. It was not Mr. Zuma. You will find no reference to Mr. Msimang's judgment, and my learned friend can correct me on that, but I've looked at the narrative of these 20 years that they rely on. You'll not find a single genuine attempt to present a balanced opinion of why we're here 20 years down the line. There's been a reinterpretation of a narrative that suggests a spin, that suggests that Mr. Zuma is responsible for that. If you look at Judge Msimang's judgment, it was an unpleasant judgment. It's still binding today on the NPA. They were told that they delayed, that the delay was prejudicial to Mr. Zuma, that they were not prepared to run the trial at the time that they were called on to run the trial. But it's worse because when you look at what internally Mr. Downer did, was he constantly advised all the NDPPs that he had worked under. He constantly advised them that we must prosecute Mr. Zuma because if we don't, we're going to delay. But now that he is here, in his affidavit, he presents a completely different story. Mr. Zuma is even guilty of Stalingrad insofar as he defended in the spy tapes. He was cited as a party when the DA brought the application. That application, that judgment, just for his involvement, is part of his pre-trial litigation, which is adopted, and bearing in mind the definition of Stalingrad, which has been given by the courts. He is wasting the court's resources by defending himself against the DA in circumstances where he's been cited as a party, together with the NPA. So I'm saying, my Lord, I urge your Lordship, in the time that I have, it's not possible for me to go through the judgment of the Supreme Court of Appeal in order for your Lordship to appreciate just how scathing the Supreme Court of Appeal was about the conduct of the NPA. But I can do just one thing, which just puts which should put the court into no doubt about what the Supreme Court of Appeal, the choice words there to make regarding the NPA's conduct, which is why it's surprising that Mr. Downer, in his narrative of what has gone wrong, would not mention the wrongs that the NPA have done. And bearing in mind your paragraph 91 that I've referred to, one must ask the question, if Mr. Downer were to get any of the information that is referred to by Mr. Hofmeyer in his affidavit that is referred to in the judgment of the spy tapes, if any of that information about the involvement of foreign spies, the involvement of telephone conversations between former NDPPs and the current directors who were responsible for Mr. Zuma's case, the things that reduced Mr. Downer to tears, if he had found that, he would not have disclosed it. He would not have disclosed it, partly because he does not believe that information that relates to abuse of the prosecuting authority in order to advance political outcomes does not affect fair trial rights. So Mr. Zuma would not have known, for example, the contents that are set out in Mr. Hofmeyer's affidavit. You'll also find that Mr. Downer gloats about having been successfully vindicated in the SCA. He says, oh, now in the SCA I was successful. My views about how the issues should go, I was successful. It's true. But how can that be a dispassionate prosecutor, as Mr. Mpofu says? How can that be a prosecutor that should be trusted with the power to prosecute impartially, dispassionately, and without any other interest? In other words, we would not know the abuse that went into, manipulations that went into Mr. Zuma's case if Mr. Downer was the only one responsible for the case, which would have been a breach of section 99 of paragraph 91 of the judgment I've just read. My Lord, perhaps another easier, I would refer your Lordship to page, to have regards to what Mr. Zuma says paragraph 28 of the affidavit, but I wish to particularly refer
Founding affidavit.
of the founding affidavit. Yes, it starts from paragraph 29. My Lord, I'm not going to read those paragraphs, but the paragraph I really want to go to is paragraph 65, and that's with reference to. So in paragraph 64, we say, in addition to the NPA Code of Conduct, prosecutors are also bound to act in accordance with ethical standards set out in the NPS Manual on Ethics, titled Ethical Duties of Prosecutors, a Practical Guide to the Ethical Code of Conduct for Members of the National Prosecuting. It's a guide. It appears at Annex JGZ 20. Under Chapter 1 of the NPS Ethics Manual, under the heading Conflict of Interest, the following paragraph bears relevance. Paragraph 1.1.2, prosecutors should recuse themselves where a perception that objectivity is compromised, exists, or could exist. Now, you'll have seen that Mr. Downer, although denies it, and I don't know whether it's out of the fact that he has forgotten this point or not. But, no, actually, in fairness, he doesn't. But in the heads of arguments, you will see that on behalf of Mr. Downer, the submission is made that he was not an investigator. He had never been designated as an investigator. But that that allegation is belied by the designations that were made, or what were made, which he attaches to his own affidavit in his affidavit, which designations make it clear that he is being designated.
Sorry, Mr. Masuku, does he say anywhere that he has never been designated to investigate? Does he say that?
That's very important. That's a very important question, my Lord, because I will show your Lordship that on page on page 623.
Just to make things easier for me, just say, refer me to the answering affidavit.
The answering affidavit, my Lord, the answering paragraph starts at 521, and you will see the designations. They appear as annexures.
Paragraph.
Let me just take your Lordship to 623. Because that's where you'll see the designations themselves.
I'm looking at the answering affidavits separately. I mean, not in accordance with the index, because
I understand, my Lord, that
somewhere along
you are
the line.
at the affidavit, but I would urge your Lordship to go to the annex, the actual designations that he attaches as an annexure,
Right. Okay.
supporting the fact that he was in fact designated as an investigator.
Yes. Well, I'm alive to that, to the fact that he does state that he was designated as an investigator. So the question I'm asking is, does he say anywhere in the affidavit that he was not investigating?
No, he does not. But but in the heads of arguments, you will see that allegation is made.
Ah, I see.
So, my Lord, the point I was trying to get at is the one where I referred your Lordship to paragraph 65, which specifically says that objectivity is compromised, exists or could exist.
Yes.
On the could exist, it is clear from Mr. Downer's reinterpretation of what went wrong in the 20 years, where he blames everything on Mr. Zuma, that he would not, half the things that are in Mr. Hofmeyer's affidavit would not have come to light if he was responsible for the entirety of the whole thing. And then, if you go to paragraph 65.2, my Lord, I know that my time is I've already gone over by 2 minutes. I don't want to be unfair to the allocation that we did to my learned friend, Mr. Batlender. Can I just make this one point and then I'll just...
Let me just give you 5 additional minutes, Mr.
5 additional minutes. I'm indebted to your Lordship. You'll see, my Lord, there that in paragraph 65.2, a prosecutor should never put himself or in a position where he or she could eventually become a witness in his own case. Mr. Downer is slam bang right there. He's a witness in his own case. If you follow the Supreme Court of Appeal directive, which is that the trial court will determine abuse of process complaints, which is where we are. Mr. Downer at some point will be asked to answer questions he's being asked to answer now. Did he or did he not leak information of the NPA to Mr. Samsol? We're debating that question now. And you'll see how he responds to it. He also reinterprets it because he says, well, yeah, I spoke to Mr. Samsol, but I didn't leak any information. But that's not true, because you'll see in those conversations, my lord, because of time, you'll see those conversations, that in those conversations, Mr. Downer was very, very clear to not want to be named as a source of that information that Mr. Samsol was asking him. He didn't want to be known as a source, and he was right to not want to be known as a source. But in these proceedings, what Mr. Downer tells us is that I was authorized. He was authorized to disclose that information, and relies on the media policy of the NPA, and he suggests that he could have been a spokesperson for the NPA. Of course, that's not true. The spokesperson of the NPA would have not said to Samsol, please don't disclose me as a witness for that thing. So, my lord, this case, just to round up, you would have appreciated the judgment of the Supreme Court of Appeal in the spy tapes, where the judges actually said right at the beginning, T.S. Eliot spoke of the recurrent end of the unending. And then he goes on to say, no, this judgment on its own, and that would be paragraph 3. He says, well, this judgment on its own, this continuing saga, is not going to end here, because they fully appreciated how badly the NPA had handled this case, and that the manner in which the NPA had handled this case would invariably lead to pre-trial litigation of the nature we're engaged in now. What has not helped is that Mr. Downer has tried to essentially spin a new narrative of why we are wrong, why we're here for 20 years. He says Mr. Zuma is responsible for it. And that cannot be a prosecutor who is acting as the code of conduct and all the other requirements of an impartial prosecutor would be required. If he came across information that was to the advantage of Mr. Zuma, it's very unlikely that Mr. Downer would disclose that information. That's because it's clear how he reinterprets the history of this matter as a matter that has been fully delayed because of Mr. Zuma's pre-trial litigation. My lord, I could go on with explaining so my lord, I would urge you to look at the Samsol conversations. Yes. You will see there that Mr. Downer is not entirely truthful when he says that he was speaking as a spokesperson and that his conduct there was allowed by the policy of the NPA. And my lord, a prosecutor ought to be trusted. Ought to be trusted by the accused person, ought to be trusted by the courts, ought to be trusted by the public. If there's one lie that a prosecutor tells or conceals, then that prosecutor must step aside, because it's clear that that kind of conduct would not be correct conduct. My lord, Mr. Downer was very emotional with this case. We all know that at some point he broke down when he was told about the level of abuse that it had taken for the NPA to get to the point where that it got.
Yes. That sums up your argument, Mr.
It does, my lord. It's just my both Mpofu and I'll start with the senior one.
No, don't do that.
My Lord, the last issue which I've not dealt with, and if with the court's indulgence, I would ask for a leave to issue a post-hearing note on it. The Glenister point. There is a lot that I would have wanted to say about that Glenister point, but I appreciate that I have no time to make those points. And if your Lordship is all right, I will send the note to my learned friends, and they can respond to that note. I've got it as a written note, and I can simply put that note for the court to have considerations of the note. My Lord, that unfortunately would be my time, as your Lordship has given to me.
Yes, thank you, Mr. Masuku.
My Lord,
Mr. Mpofu now.
I know, my Lord. My Lord, you can deduct this from my reply. Literally 1 minute, my Lord.
Yes.
It would be unfair to raise this point in reply for the first time to my learned friend. I won't even develop it, my Lord. It's just to build on the Stalingrad point that Mr. Masuku made. Two quick submissions, my Lord. The first one is, if you go to, well, let's first accept that Stalingrad, the accusation of Stalingrad involves not just the delay, as they want us to believe, or whether you succeeded or didn't succeed, but it also involves malafides. So without malafides, you can't be accused of Stalingrad. Then, my Lord, I'll refer you to paragraph 30 of our founding affidavit. It says there, my Lord, this is Mr. Zuma. After coming to learn about my medical records and correspondence of my doctors being given to a journalist ahead of them being filed in court, and details of the same subsequently being published in the media, and the way it was, I felt my rights to privacy and dignity were grossly violated by the prosecutors in my case. Upon seeking legal advice about my remedies, I was advised to lodge a criminal complaint with the SAPS and so on and so on. The only point I want to make, my Lord, because I don't have time to develop it, is that this, Mr. Zuma says to this court under oath, I went to the police station as a result of legal advice that I obtained. And it's not denied. So how can you then say, a person who says, I was advised by my lawyers to, this is the course to follow, and you say that they were malafide? And I'll refer your Lordship to page 577, I think it's paragraph, I don't know what the paragraph number is, in the answer. The answer to that, it simply says, we take note of this, or we don't know, whatever, but there's no denial. So if it's common cause that he was advised by his lawyers to lay criminal charges, how can in the same breath they say he was, so that's the first point. The second one, my Lord, the last one is, and again, also like Mr. Masuku, because I don't have time. If you look at the best judgment, my Lord, is the stay of prosecution judgment, which really greatly puts step by step what happened. And the point that Mr. Masuku makes, it is said in that judgment that vis-a-vis the spy tapes thing alone, both both the NPA and Mr. Zuma opposed because they were cited. That took about 10 years to resolve, 9 to 10 years. And so, but what you are being told is that both parties, NPA and Mr. Zuma, opposed the DA's application. But Mr. Zuma was doing it for Stalingrad, but the NPA was doing it to assert the constitution. What is that? Either they were both practicing Stalingrad, or they were both exercising their rights sorry, my Lord. Their rights to, and you'll find that, my Lord, at no, I'm sorry, my Lord. It's in the other bundle. At 329 of the authorities bundle, as well as 327, that's paragraphs 141 and 145 of the stay judgment, where the judge says, it was also important for the NPA to await the outcome of the Sheikh appeal, as it would definitely have an impact on Mr. Zuma's prosecution. Any delay during this period is regarded as systemic, not Stalingrad. And both parties, that's the NPA and Mr. Zuma, are equally liable as they both participated in the litigation leading to the delay. As such, it is not open to Mr. Zuma to complain about the delay. And I'd say, as such, it is not open to the NPA to complain about the delay. At 1:45,
It's
there's
not open to both.
Yes, they both. That's why I'm saying, my lord, what's sauce for the goose is sauce for the gander. If one of them opposed, in other words, they can't accuse each other and say that delay. They were both responsible for that delay. In fact, even up to the appeal, you'll remember, my lord, they appealed all the way up to the Court, both of them. But now the one says, no, we were doing it for holy reasons, but he was doing it for evil reasons.
No, the point has been made, Mr.
Yes, my lord. So, sorry, my lord. Just the last reference. It's on 145. Says, timing of the service of the indictment does not impact on the strength of the state's case, as the NPA and Mr. Zuma formed common cause in opposing the DA review application. The whole period between between April 2009 to October 2017 cannot be termed unreasonable, as they were both complicit in their actions. As court pleases, ma'am. I just thought if I raise it for the first time in reply, it would be unfair to my learned friend, because
Thank you,
he
Mr.
needs to deal with it up front. As court pleases.
Yes, thank you, Mr. Mpofu. Can we take a short adjournment before we hear you, Mr. Portlander, please? We'll stand adjourned for 15 minutes. Court adjourns.
For how long have you adjourned? Excuse me? 15.
Thank you, Ms. Portlander.
That's a complete. My Lord, I'm a newcomer to this long drawn-out case, like your Lordship. My involvement started early this year. Since I've been involved, I've heard the arguments which were raised today by our learned friends 4 times. I heard them raised in the application for an order setting aside the private prosecution. Then I've heard the same arguments made in the application for leave to appeal against the order setting aside the private prosecution. I heard them made in the application for an implementation order under Section 18(3) of the Superior Courts Act. I heard them made again for the fourth time in the SCA in the appeal against the Section 18.3 order. I've heard the same arguments raised 4 times, sometimes with a different label attached to them, and they've been rejected each time. The most recent of these judgments was in the SCA on the 13th of October, 2 weeks ago. The judgment of the SCA has significantly narrowed the issues in this case, in this application, which is before your Lordship. And that is because the SCA has authoritatively decided a number of the issues in this case, in this application. So, for that reason, my first topic will be a review of what the SCA decided 2 weeks ago. The SCA's judgment makes it unnecessary to examine in detail a number of the complaints raised by Mr. Zuma, which one heard this morning at some length, because the SCA has rejected them. And I will take the court through the main findings of the SCA. That's the first topic I will address. The second topic I will address is a matter referred to by learned friends, which is the relevance of previous decisions of the courts and the binding nature of previous decisions of the courts, res judicata, if you like. Res judicata and appeals. And your Lordship will have seen that Table A to Mr. Downer's answering affidavit sets out all of the issues raised by Mr. Zuma and sets out in which case they were dealt with, in which case the judgment was given, and where in the judgment. And I won't take your Lordship there. The updated version of Table A is attached to the supplementary answering affidavit, Volume 8, page 736, and it includes the full court judgment, which set aside the private prosecution, but of course it doesn't include the recent SCA judgment. So that's the second thing I will address, is the relevance of those past decisions. Then thirdly, I will address each of the pillars on which Mr. Zuma makes his case, the 4 pillars. And I will seek to show your Lordship that in each instance, firstly, the complaint has already been rejected by the courts, and secondly, for the rest, they are based on a misunderstanding of the law and in some cases a misstatement of the facts. So let me come then to the SCA judgment, where I start. Does your Lordship have a copy of that judgment in front of you?
Yes, I do.
Thank you, my Lord. At this stage, I'm going to refer to only 2 of the critical passages in the judgment, and I will refer to others later as I develop my argument. I'm going to refer to the question of the nature of the private prosecution which Mr. Zuma has brought, and which is really the main trigger for this application. And secondly, Mr. Zuma's Stalingrad defense. As far as the nature of the private prosecution, what did the SCA say about the nature of the private prosecution? The Lordship will find what the SCA said on paragraph 10, at paragraph 10, on page 8 of the judgment. Is Lordship with me?
Paragraph 10.
Para 10, page 8.
Yes.
Para 10, the SCA says the following. What emerges is that the...
Page 6 of my judgment.
You're quite right. Page 6 of mine also.
Yes.
My eyes are beginning to fail me. What emerges is that the central purpose of the private prosecution is to enable Mr. Zuma to have Mr. Downer removed as the prosecutor on the basis that he, Mr. Downer, stands accused in the private prosecution. That's why it's now before your Lordship. In paragraph 11, then, the court goes on and says the following. The facts demonstrate that the private prosecution of Mr. Downer is an abuse of the process of court for multiple reasons. First, as the High Court found, it was instituted as a further step in a sustained attempt by Mr. Zuma to obstruct, delay, and prevent his criminal trial. This is an ulterior purpose, and the institution of the private prosecution was accordingly unlawful. Second, it was instituted in order to have Mr. Downer removed as the prosecutor in Mr. Zuma's trial. This too is an ulterior purpose, which renders the private prosecution unlawful. And third, the contemplated private prosecution is patently a hopeless case. It is obviously unsustainable. Mr. Zuma has not made out any possible basis on which Mr. Downer might be convicted, even on Mr. Zuma's own version of the facts. That too renders the private prosecution an abuse of the process of court. So the SCA has spoken unequivocally. The private prosecution is an abuse, and this is a hopeless case. Well, the prosecution is a hopeless case. Its central purpose is to enable Mr. Zuma to have Mr. Downer removed as the prosecutor through this application to your lordship. And we say that those findings of the SCA are with respect binding on this court. I'll come back to that. Secondly, there's the question of the Stalingrad defense and the long argument about the 20 years and how many of the 20 years and so on. This is what the SCA said on that issue. The lordship will find it at paragraph 7, first part I rely on page 4. Where the SCA says the following: a key plank of this appeal is that no other court had been as ready to accept the characterization of Stalingrad as was the High Court in this matter. That's not entirely accurate. In Democratic Alliance versus President of the Republic of South Africa, that was the case about the costs. 3 judges of the Gauteng Division of the High Court, Pretoria, found that Mr. Zuma had adopted a Stalingrad defense strategy, which had cost the state and hence the taxpayer a total amount of between 16 and 32 million rand. Mayor J, Ladwaba DJP, and Kubushi J, concurring, observed that the law reports are indeed replete with judgments dealing with Mr. Zuma's criminal prosecution. The court noted that Mr. Zuma had ultimately been successful in every one of the challenges, almost always with an adverse costs order. Unsuccessful in every one of the challenges, almost always with an adverse costs order. Paragraph 8, the court goes on, says in it's a passage which my learned friend referred to, in 2017, NAVSA ADP commenced a judgment of this court with a reference to T.S. Eliot's recurrent end of the unending. And then over the page, top of page 6, this abbreviated history illustrates that on any reckoning, the scale of litigation, which is likely unprecedented in the South African courts, justifiably attracts the epithet Stalingrad. That's what the SCA found. And it's all very well for my learned friend to say this nonsense. He refers to what he says, the nonsensical theory of Stalingrad. Well, it's a nonsensical theory which has been embraced and supported by the Supreme Court of Appeal and by the full court and by the previous full court in Gauteng. So the court knows, this court knows, that Mr. Zuma is implementing a Stalingrad defense. And it knows this for at least 3 reasons. Firstly, it knows this because in 2007, Mr. Zuma's counsel, the late Mr. Kemp, told the High Court that this is what his client was going to do. He said so in terms. Your Lordship will have seen that, told Mr. Justice Hichun. Secondly, reason your Lordship knows this is because the full bench found that Mr. Zuma has adopted a Stalingrad defense. And the third reason your Lordship knows it is that the SCA found that Mr. Zuma has adopted a Stalingrad defense. And so it doesn't really help to argue about which part of the 20 years is directly attributable to Mr. Zuma. The pattern of what Mr. Zuma is overwhelmingly clear, what Mr. Zuma has been doing is overwhelmingly clear, and he's doing what his counsel said he was going to do, he's doing what the full bench found he did, and he's doing what the SCA found he did. And we say for the reasons which I address in the next section of my submissions, it's not open to Mr. Zuma to dispute any of this. And with respect, it's not open to this court to make any findings which are inconsistent with what the full court found and the SCA found. Namely that 1, the private prosecution is an abuse. Secondly, the private prosecution is a hopeless case. Thirdly, the private prosecution was instituted with the ulterior, unlawful motive of trying to get rid of Mr. Mr. Downer as the prosecutor. And fourthly, the private prosecution is part of a Stalingrad defense which Mr. Zuma is implementing. All of those we submit is binding on this court. And I don't propose to re-argue all of those things yet again. It's done. It's done and dusted. I do need to say one thing about this, that in the heads of argument of our learned friends, you will find that our learned friends say that the courts have repeatedly rejected the Stalingrad theory. They give no source for that statement. There's only one they've given us previously, which is a judgment by Justice Kuhn in a postponement application, and I'll deal with that in a moment. But it's not true the courts have repeatedly rejected the Stalingrad theory. The full bench and the SCA have adopted and embraced the Stalingrad theory. As to what happened with Justice Kuhn, what was happening what came before Justice Kuhn, we can get your lordship the transcript, which was made available to one of the previous courts if necessary. What happened in that case was, thank you very much. This was what had happened was that Justice Kuhn rejected the special plea, the section 106(1)H special plea. Mr. Zuma applied to Justice Kuhn for leave to appeal. That was refused. He then applied to the SCA for leave to appeal. That was refused. And then, at that stage, and then he applied for reconsideration by the president of the SCA. And that application hadn't been dealt with by the time this matter came before the criminal court, before Justice Kuhn.
The reconsideration application.
Yes, the reconsideration application hadn't been decided yet. And but then it came before this, the criminal case came before this court. And Mr. Zuma applied for a postponement, saying, please give me a postponement until the reconsideration application has been decided, because that may turn things around. And the prosecution said, well, this is all part of a scheme of Stalingrad defense. And what Justice Kuhn said was, well, Mr. Zuma has the right to appeal. And in the ordinary course, that is what he should be allowed to do. On the facts before me as they stand, I'm not able to make the finding that there's a Stalingrad defense, and therefore I allow the postponement. That's what happened, and one can understand why. That's not a rejection of the Stalingrad defense. It was in the context. It was saying.
Actually, no pronouncement was made.
No, in this case, on the facts before me, I can't make that finding, and particularly when you weigh that against the right of appeal and the rights of reconsideration. That's the only case that our learned friends have ever referred to us, where they say the courts have rejected the Stalingrad defense. But the Stalingrad defense theory has been adopted, as I say, by the full bench in Gauteng, the full bench here, and the SCA. So that's the SCA judgment. What is the relevance of these past judgments? There are two matters I want to address in this regard. The first is res judicata. Now, as your lordship knows, the res judicata is the principle that where the courts have made a decision in litigation between the parties with regard to the same matter, they can't raise it again. They can't come back and raise it again. And the normal requirements for res judicata are that it's between the same parties, it's about the same matter, and it's the same cause of action. And then it's res judicata, and that's the end of the matter. And what the authorities show clearly is that the courts will relax the test in appropriate cases where not all of the requirements are met. That's sometimes called issue estoppel, which is also, in fact, res judicata. That's another form of res judicata. And the leading case, which has been followed again and again and is well known, I'm sorry it's not in our heads of argument, it's Smith versus Porritt. I'm not sure whether it's the same Mr. Porritt. I was once in another case against Mr. Porritt, but it's Smith versus Porritt, 2008, volume 6 SA, 303 SCA, paragraph 10. If I can just read to your lordship what the court said in that matter. The court said, Following the decision in Boshoff versus Union Government 1932 TPD, the ambit of the exceptio rei judicata has over the years been extended by the relaxation in appropriate cases of the common law requirements that the relief claimed and the cause of action be the same in both the case in question and the earlier judgment. Where the circumstances justify the relaxation of these requirements, those that remain are that the parties must be the same and that the same issue must arise. Broadly stated, the latter involves, that's the same issue, the latter involves an inquiry whether an issue of fact or law was an essential element of the judgment on which reliance was placed. So it was a finding of fact or law, an essential element of the judgment. Where the plea of res judicata is raised in the absence of a commonality of cause of action and relief, it has become commonplace to adopt the terminology of English law and to speak of the issue of issue estoppel. But as was stressed by Botha J.A. in Commissaris van Binnenlandse Sake, Binnenlandse Inkomsten versus ABSA in 1995, this is not to be construed as implying an abandonment of the principles of the common law in favor of those of the English law. The defense remains one of res judicata. The recognition of defense in such cases will require careful scrutiny. Each case will depend on its own facts, and any extension of the defense will be on a case-by-case basis. Relevant considerations will include questions of equity and fairness. So what we know is that the core issue is, in this case, have been decided over and over again by our courts. And we say this is a classic case for issue estoppel. Mr. Zuma can't keep on forever litigating issues which have been repeatedly decided against him. Those matters have now been adjudicated, and he is bound by those findings. And the question of equity and fairness is quite clearly that there is no equity and no fairness in allowing him to raise the same thing over and over and over and over again. The equity and fairness in saying there have been a series of judgments of the courts, those are not binding. Or he's bound by them. The second issue in relation to past judgments is this. My learned friend Mr. Mpofu referred to it briefly, which is what happens when a court has given a judgment and the judgment is then the subject of a pending appeal. We know that an appeal usually suspends the order under Section 18 of the Superior Courts Act. But what is the position with regard to the findings that the court has made as opposed to the order? The order is not executed. And what about the findings? And this is explained by the SAA in last month's judgment. The court addressed it, and your lordship will find it at paragraph 15 of the SCA judgment on page 9. Page 9, paragraph 15, the end of paragraph 15 refers to the finding made by the High Court, and then it says, then the court says the following: the finding stands until set aside by a court of competent jurisdiction. And that was the point made by Justice Ponan during argument in court. He said, no, but that judgment stands. Even though it's subject to an appeal, the judgment stands until it's set aside. And the same was decided by this court in a case called Release Mandela Campaign versus the President. It's one of the late arrival cases which we referred to your lordship. Yeah. Does your lordship have it?
Just a moment, I did receive it, but let me just have a look. There is it, yes, I've got it.
It's at page 213 of the judgment, my lord.
Judgment of Howard and Broom.
Yes, that's it.
Page?
Thank you, my lord. At 213 of the, what happened in that case, I'm not going to take your lordship to the judgment. It's there, page 213A. What had happened in that case was that there was a challenge to some emergency regulations. And the same challenge had been raised in a previous case, and the regulations had been held invalid. But that was subject to a pending appeal. And so what Justice Broom was dealing with, he said, well, now, what about in this case? We've got a case raising the same issue, which has already been decided by a previous court, which is subject to appeal. And he said, a full bench decision, he said, that decision is binding on us. It's binding on us until it's set aside on appeal. And he said, therefore, we make the, he basically did the same as the previous court had done. He set aside certain of the regulations as the previous court had done, and he upheld certain of the regulations as the previous court had done. And the Release Mandela campaign is direct authority, as the SCA now is, for the proposition that the fact that a case is subject to there's a pending appeal stops execution, but it doesn't mean the judgment disappears into thin air. It still stands and it's valid law until it's set aside on appeal. The relevance is that in this case, Mr. Zuma is attempting to appeal against the full bench decision to set aside the summons. He's applied for leave to appeal to the High Court. This court rejected it. Is now applied to the SCA. The decision of the full bench stands. It stands unless and until the SCA or the Constitutional Court says it was wrong. And that's well-established law. I can just say in relation to the SCA's judgment, that's also now the subject of an attempted appeal to the Constitutional Court. That appeal, for the same reason that the judgment stands. But actually, it goes further than that. The judgment, the appeal is a nullity, attempted appeal, because there's only one appeal under Section 18.4. The SCA has held that, and I can give your lordship the reference to it. It's called City of Tshwane Municipality.
Sorry, just a moment.
I'm sorry we didn't give that to your lordship because we didn't think this argument would be raised. Well, I didn't think. I was over-optimistic.
Yeah, City of Tshwane Municipality. Case
City of
number
Tshwane Municipality.
1124 of 2022.
Does your lordship have it?
Yes, I do.
Oh, thank you. Well, then, if your lordship will see at paragraph 21 on page 9.
Just a moment. Just a moment, please. Yes.
At paragraph 21 on page 9, this is what the SCA said. Section 18.4 of the Act establishes a distinct provision that establishes a unique category of appeals, specifically designed to be utilized solely for orders made under Section 18.3 of the Act. This provision carves out a specific and extraordinary avenue for appeals in exceptional circumstances, especially when it can be proved that irreparable harm would follow if the operation and execution of a decision is suspended. The provision enhances access to court on appeal by guaranteeing one automatic appeal. Now, there has been that one automatic appeal where the SCA has heard it and has decided it. Bypassing the typical screening process outlined in the general provisions of sections 16 and 17 of the Act. The purpose is to streamline and facilitate access to courts for these specific appeals, providing a more efficient and expedited avenue for seeking redress without infringing the Section 34 constitutional right of access to courts. Paragraph 22. We endorse NAFSA JA's arbiter viewpoint in Clemeza versus Helen Suzman Foundation that Section 18.4 of the Act specifically allows for a single automatic rights of appeal, indicating that multiple appeals are not permitted under the section. He expressed it as follows: understandably, because it is such a dramatic change, only one appeal to the next highest court is permissible. No further appeal beyond this court appears competent. For present purposes, it's not necessary to decide this point. That was Judge Nafsa, and now in Tshwane, the SCA did decide the point in accordance with what Judge Nafsa had said. So the attempted appeal to the Constitutional Court against the judgment of the SCA is a nullity, and it will be thrown out by the Constitutional Court because it's contrary to law. There is no such procedure in our law. But it doesn't. But it doesn't really matter, because even if it was a competent appeal, the judgment of the SCA would stand until and unless the the Constitutional Court held otherwise. So, my Lord, those are the preliminary remarks which I wish to make. I see it's now 1 o'clock. What time is your Lordship planning to take the lunch adjournment?
Yeah, let's just proceed until you finish your argument.
Right, thank you very much. Then I want to address next the 4 pillars on which the applicant relies. And they are set out in the founding affidavit at page 45, Your Lordship will be familiar with them, and I'm going to go through each one of them in turn. And I hope that I will demonstrate to Your Lordship that each of the pillars is without foundation, and that the complaints which Mr. Zuma raises here have already been rejected repeatedly by the courts. Pillar 1. Pillar 1, Your Lordship will remember, is this, paragraph 100.1 of the founding affidavit. Yes. The mere fact that Mr. Downer is presently in the dock as an accused person in a private prosecution, in which I'm the private prosecutor, disqualifies him from acting as a prosecutor in a public prosecution. So once there's a private prosecution, he's out. The mere fact of it is out. And that's the case which our learned friends advanced this morning. There's a very short answer to this. Justice Kuhn dealt with that in his judgment in the recusal application. And in the recusal application, this is what he said at paragraphs 67 to 68. If I can lay my hands on it. Sorry, my lord, I just seem to have put it aside somewhere. Here it is, right. Paragraph 67.
I don't have the recusal application.
I don't think Your Lordship has this.
Yeah,
we'll make a copy available to Your Lordship. Do you have a pen? Okay. Can I just read Your Lordship what was said by Justice Kuhn in that case? He says, paragraph 67. He says, at the level of a general discussion, an instance might arise in criminal litigation where unfounded criminal charges are brought by an accused against a prosecutor. It might be highly desirable or even crucial that the particular prosecutor be the designated appointed prosecutor in that litigation. If the effect simpliciter of instituting a private prosecution in each and every instance as a matter of course, even if the private prosecution was totally unfounded, was that the prosecutor would be disqualified from continuing as the prosecutor, then the state would be denied its prosecutor of choice as part of a strategy, rather than the bona fide pursuit of a private prosecution of the prosecutor for crimes he or she allegedly committed in the best interests of justice. To avoid that situation, that of course describes what we say is the present situation. To avoid that situation, the circumstances and merits of any proposed or actual private prosecution might need to be scrutinized very closely, together with all other relevant considerations, to determine whether a prosecutor should be removed as a prosecutor in a particular trial. So what Justice Kuhn says is what, with respect, is common sense. The answer must be, well, it depends. If the private prosecution is unfounded, then you wouldn't allow it to interfere with the prosecutor. If the present prosecutor is needed for particular reasons, then you wouldn't be in a hurry to knock that person out. It depends on the circumstances of the case, and what this court has already held, therefore, is that the prosecutor is not discharged, not to be removed, simply by the mere fact that he or she is facing charges in a private prosecution brought by the accused. It's not sufficient to justify a conclusion that the prosecutor should be removed. One has to look at the circumstances and the merits. That's the phrase used by Justice Kuhn, the circumstances and the merits of the private prosecution. That decision of Justice Kuhn is also, with respect, binding on Your Lordship, unless Your Lordship just considers that it's clearly wrong. So, what are the merits and circumstances in this case? As to the merits, firstly, the full bench has already held that the private prosecution is without merit and that it has no prospect of success. And this court is, with respect, bound by that finding. It's a matter of issue estoppel. Secondly, the SCA has held the following. Can I take Your Lordship back to the SCA judgment? It's paragraph 11. The court, paragraph 11 at the foot of page 6, the court says the following. Third, the contemplated prosecution is patently a hopeless case It is obviously unsustainable. Mr. Zuma has not made out any possible basis on which Mr. Downer might be convicted, even on Mr. Zuma's own version of the facts. So the court and the SCA has also found that the private prosecution is an abuse of the process of court. I've shown your lordship that passage already. This court, with respect, is bound by those findings. It's an issue of estoppel. And so when one looks at the merits, what are the merits of the private prosecution? No merits, unfounded and unfounded prosecution, say 2 courts, and it's an abuse of the process of court. Secondly, as to the circumstances, the full bench has found that the private prosecution is an abuse of process for an unlawful ulterior purpose, and the SCA has found that it's an abuse of the process of court for an ulterior purpose. 8 judges, my lord, have now made that finding, and this court is, with respect, bound by that finding. What Mr. Zuma wants is to turn the law on its head. He wants to make a fool of the law and of the courts. He institutes a private prosecution, which is an unlawful abuse of the process of court. That's the findings of the courts. And then he says that the courts must now, because of his unlawful abuse, remove Mr. Downer as the prosecutor. It's entirely upside down. If there were ever a case of dirty hands, this is it. You institute an abuse with the purpose of getting rid of the prosecutor, and then you say, aha, now you must get rid of him. We say this turns the law on its head. You can't institute a private prosecution for the unlawful purpose of having the prosecutor removed, and then insist that the court must remove the prosecutor because of the abuse of private prosecution. To put it differently, you can't initiate an abuse for an unlawful purpose and then say that the abuse entitles you to achieve the purpose you were going after in the first place. That would turn the law entirely on the head and make a mockery of our courts. So that's pillar 1. Pillar 1 doesn't get out of the blocks. Kunje has said doesn't get out of the blocks, and as a matter of logic, it doesn't get out of the blocks. Then one comes to pillar 2. Now, pillar 2 is the charges relating to the alleged leak to Ms. Morn. And Mr. Zuma says that the 2021 leak, quote, goes to the heart of the criminal charges, close quote. He says that's at the heart of his private prosecution. I'm not going to take your lordship there, but I can just give your lordship the reference. It's founding affidavit, volume 1, page 47, paragraph 105. Now, we deal with this fully in our heads of argument from paragraphs 21 to 33, and I'm not going to take your lordship through all of this. It has been rehashed and rehashed over and over and over again, and I'm not going to try to rehash it again. We stand by what is said there, but we say that the complaint is unfounded. It's a disingenuous and contrived accusation. And we also say that Mr. Downer is innocent of any wrongdoing on this ground for at least 2 reasons. Firstly, he had nothing to do with the release of the letter to Ms. Moore. He only discovered it after the event. And secondly, Mr. Breitenbach sent a copy of the unsigned affidavit to Ms. Moore only after Mr. Downer had sent those documents to Justice Kuhn. Your lordship will remember the sequence of events. Mr. Downer sends the document, sends an unsigned affidavit and the letter of Dr. Mduchwa to Justice Kuhn. And he says, I'll file the signed copy tomorrow morning. After that, Mr. Breitenbach sends a copy of the unsigned affidavit with that letter to Ms. Moore. That's the sequence of events. And the courts have held, the SCA has held, and the full court has held, that once the papers were delivered to Justice Kuhn, they became part of the record. They became public record. And so it's absolutely untrue for our learned friend to say that Mr. Downer lied when he said that they were part of the public record. They were part of the public record. They were part of the public record, and the courts have found that they were part of the public record. They were filed at court. They were lodged with. Mr. Downer is absolutely clear and transparent about what happened. He lodged an unsigned copy and the letter with Judge Kuhn on the public holiday. That triggered the fact that this was now a matter of public record and was before the court. It was not a secret, it wasn't a secret letter to Justice Kuhn. And to all the parties. They sent it to Justice Kuhn and all the parties. And then the next morning, the signed copy was filed at court. And there's no blue lie or white lie or red lie or green lie. There's no lie at all. What Mr. Downer said is absolutely what the truth is. And Mr. Mpofu's accusation, cast in rather vivid terms, is with respect simply unjustified. So that's what happened as to the alleged disclosure with regards to Ms. Morn. And I've dealt with what we've said. I refer to our heads of argument. Can I show your lordship what Justice Kuhn said in the section 106(1)H special plea judgment? That's the first removal case. You'll find it in the judgment at paragraph 263. There are so many judgments. My poor Justice Kuhn must have been in a state of exhaustion by the time he refused himself. I'm just looking for the 106(1)H application. Here it is. At page, does your lordship have it?
Yes, I have it.
Page 200, paragraph 263. Which is at page 99.
Page 99.
Justice Kuhn says the following. He deals with the sequence of events and Mr. Tusini and Dr. Mdutra, or General Mdutra, and he then says paragraph 263. The significance of the sequence lies not so much in Brigadier General Dr. Mdutra confirming the affidavit of Mr. Tusini when it was still only in draft form, but in him confirming the correctness of his medical report letter, which would form an annexure to the affidavit of Mr. Tusini, which was yet to be signed on 8 August, for it to be filed in court. The only inference is that the intention at that point was that the letter of 8 August would form part of the application for a postponement, pursuant to the terms of my directive, which would mean that it would become public when filed. That would be inconsistent with the protestations that the letter was a confidential document of which the confidentiality, if in fact it was confidential in the first place, was not waived. We say with respect, Justice Kuhn did not consider what the effect was of filing it with him. There was already a public record at that stage. Then he says, paragraph 264, the letter had furthermore been disclosed to Mr. Downer, Ms. Laika, and the DPP of KZN without any specific restrictions as regards confidentiality by the head of the Correctional Centre at Escort on 8 August 2021. The letter did not contain anything significantly confidential. Paragraph 265. The letter of Brigadier General Dr. Mdutra is vague and general in its terms and does not disclose any particularity which could be said to amount to a violation of Mr. Zuma's rights, his rights to privacy. Specifically, it does not mention the medical condition Mr. Zuma suffers from. So that's what was said by by Justice Kuhn. Then one has, and that we know that that judgment was taken on appeal, or was an attempt to take it on appeal, firstly to the High Court, then to the SCA, then to the Constitutional Court. They all came to nothing. So that finding stands. Then there is the finding of the full bench in the application for the set-aside of the summons in the private prosecution. And your lordship will find that at page 795, I think it's in our supplementary answering affidavit. If your lordship will go to page 795, your lordship will find what the full bench found at paragraph 107. full bench said, Kunje found, and with which we respectfully agree, that the document was not confidential.
So where you at now?
I'm sorry, my lord. It's page 795.
Yes. Paragraph?
Paragraph 107. 107.
Right.
This is what the court found. This is the full bench. Kunje found, and with which we respectfully agree, that the document was not confidential and in any event confidentially had been waived by the filing of the respondent's affidavit. There's been much debate as to the timing of the affidavit posted by Mduchwa and the date of the letter, but this has been adequately dealt with in Kunje's judgment. We respectfully align ourselves with those remarks expressed by him. In addition, that these documents are public documents and can be made available is something that must not be not be lost sight of. So that's what the full bench said about this letter of the doctor, and then the SCA dealt with the matter as well. And the SCA dealt with it at paragraph 12 of its judgment. Which is at page 7 of the SCA judgment, where they deal more broadly with the matter. Is your lordship with me?
Yes.
Paragraph 12. As to the third, Mr. Zuma's case against Mr. Downer consists of two charges. The first charge is a complaint that Mr. Downer disclosed confidential or private medical information about Mr. Zuma to Ms. Maughan in breach of Section 41(6) of the National Prosecuting Authority Act. The undisputed fact is that Mr. Downer made no such disclosure to Ms. Maughan. The disclosure in question was made by Advocate Breitenbach, SC, a member of the prosecution team. In any event, both Kunje and the High Court found that there was no disclosure of confidential or private information. Each thus rejected the charge as unfounded. In reply before us, counsel suggested that Kunje had not made a firm pronouncement as to the confidentiality of the information, a suggestion neither raised in the papers nor foreshadowed in the heads. However, that is to misconstrue the effect of Kunje's judgment. Kunje found that Mr. Zuma's doctor's note was not truly intended to be confidential. It did not contain any confidential information, and its disclosure did not constitute an actionable violation of his rights. And so that's what the court found. And I can go the lordship can go back one page, paragraph 11 on page 6. I apologize for repeating this passage again, but I have to in order to make the argument. Right at the foot of the page, the SCA found Mr. Zuma has not made out any possible basis on which Mr. Downer might be convicted, even on Mr. Zuma's own version of the facts. And the court knew that this was a complaint under Section 41(6) of the NPA Act. And the court found there's no basis, no possible basis, or no possible basis was made out on which Mr. Downer might be convicted under Section 41(6). So 9 judges in this case have held that this complaint, which a learned friend says goes to the heart of the private prosecution, is simply unfounded. Mr. Downer did not commit any offence, and the courts have repeatedly said so. That brings me then to Pillar 3 of the applicant's case. And Pillar 3 is, as your lordship knows, it's the alleged disclosure to Mr. Sol some years ago. When was it? It's difficult to remember. This is disclosure in 2008, 15 years ago. And this is dealt with fully in our heads of argument. Again, I'm not going to I'm not going to take your Lordship through all of that. It's there to be read if your Lordship is so inclined. Not necessary to go there because it has been dealt with by the courts already, and the courts have decided it. But can I just summarize what we say in our heads of argument in this regard? We say, just find my heads. We say that the complaint was abandoned and dismissed by Mr. Zuma, by his counsel. We say that Mr. Downer didn't disclose any confidential information. We say any disclosures were lawful, and we say this too goes nowhere. This matter too has, of course, been dealt with by the courts, by all of the courts. And can I show your Lordship what is said in the answering affidavit? Page 575. Paragraph 118.5. If I can first go to paragraph 118.5 on page 575. Is your Lordship with me?
Yes.
This is what Mr. Downer says. I did not disclose any information to Mr. Soul relating to Mr. Zuma's case. I merely described in the abstract the mechanisms by which the NPA obtains mutual legal assistance. Your Lordship will see that from the transcript. This is not disputed in the replying affidavit. The replying affidavit deals with this paragraph at paragraphs 96 to 97 on pages 859 to 860, and it is not disputed. So it's not disputed that Mr. Downer did not disclose any information to Mr. Soul relating to Mr. Zuma's case. He merely described in the abstract the mechanisms by which the NPA obtains mutual legal assistance. That's a fact, and with respect, that disposes of this whole argument about Mr. Soul. Then can I take your Lordship to what is said in paragraph 233 by Justice Kuhn. This is the 1061H judgment, and page 233 starts on paragraph 233 starts on page 88, the foot of the page. So Your Lordship is ahead of me. This is what Justice Kuhn found. He said, insofar as Mr. Zuma seeks to impute the leaking of confidential information about the investigation and prosecution to Mr. Soul, to Mr. Downer specifically, the allegations over the page are based on speculation, so starting out, are based on speculation, unsupported by admissible evidence from Mr. Zuma. The facts are confined to what Mr. Downer has admitted. Then in paragraph 234, he deals with the waiver during the hearing of the stay application. In paragraph 235, he says as follows: however, insofar as reliance on the leaks might be found not to have been waived as a ground of complaint in the context of this trial, Mr. Downer admits to having had certain discussions with Mr. Sam Soul of the Mail and Guardian, but denies that these were related to the investigation and prosecution of Mr. Zuma, except for two questions related to the workings of the International Cooperation in Criminal Matters Act and international requests for mutual legal assistance. He denies that these involved any confidential information regarding Mr. Zuma's prosecution being disclosed. That version of Mr. Downer is not gainsaid. So that's a fact. And then at paragraph 237, this is what Justice Kuhn said, referring to the alleged leak to Mr. Soul. This is accordingly not a ground to find that Mr. Downer does not have title to prosecute, or that he should be removed as prosecutor, He had not disclosed anything confidential regarding Mr. Zuma to Mr. Sol. Then it was dealt with by the full bench. This is tedious, my lord, but I need to show this to your lordship in the light of our learned friend's insistence that this is raised over and we start all over again as if nothing has ever happened in this case. And this is what was said in the full bench judgment. Firstly, paragraph 103.
Paragraph?
103. I hope I've got the right judgment. Can I just check?
Page 32.
Page 13. Yes, my lord. Page 32 of the judgment. Of the judgment in the application to set aside the private prosecution.
Judgment of the full bench of this.
Judgment of the full bench, my lord. Yes, my lord. That's right. And what it says is, firstly, it's not disputed that in terms of section of the 2006 NPA directives on media statements and public communications, deputy directors and senior public prosecutors may act as spokespersons for the NPA on matters pertaining to prosecution policy and/or any criminal prosecution. The purpose behind responding to the media or public inquiry or to public inquiries about matters is to assist the public to understand the nature and course of criminal proceedings at the time, not acting to the prejudice of the parties before the court who cannot defend themselves against public comment. And what he said was entirely innocuous. He said, "Don't quote me, just take this as a fact," and so what? Doesn't make it unlawful. And then paragraph 110. Paragraph 111, I think, would be most useful, where the full court found the following. Downer has always denied that he disclosed any information to Mr. Sol relating to the respondent's case, and indicated that what the exchange between him and Mr. Sol concerned related to Mr. Sol's queries about the procedure to be followed when the NPA obtains mutual legal assistance from other countries. This has not been disputed by the respondent, Mr. Zuma. Paragraph 113 on the next page, a telling passage, if I may say so, from the judgment of Justice Kun, of the full bench. Paragraph 113, Kunje further found that the respondent had not gainsaid or disputed Downer's account of his conversations with Mr. Sol. Consequently, the charge relating to the alleged leak to Mr. Sol is unsustainable. It also demonstrates an ulterior motive on the part of the respondent, which in turn constitutes an abusive process. Why does the respondent raise this now again, when it's already been dealt with in two other proceedings and disposed of in both the application for a permanent stay and in the Section 106 plea pleadings before Kunje, and in circumstances where this court does not have jurisdiction to deal with the charges in respect of this count? The only reasonable inference one can draw is that the respondent seeks to discredit Downer and prevent him from exercising his duties as a prosecutor in the criminal trial. And then again, it is dealt with by the SCA, which is shorter, is briefer. It's the SCA judgment, paragraph 12. It's on page 7 of the SCA judgment, my lord. Is your lordship there?
Yes.
At the foot of page 7, fourth line from the bottom. The second charge relates to a conversation that Mr. Downer had with the journalist Mr. Sam Sowell in 2008. Mr. Zuma has never previously sought to bring any complaint or charges against Mr. Downer in this regard. And like the first charge, the information disclosed was not confidential or private. The facts show that Mr. Downer was authorized to make the disclosure. Both Kunje and the High Court considered and also rejected the charge as unfounded. So Pillar 3 is also without foundation. The courts have said again and again and again, this has no foundation. Yet evidence of Mr. Downer is not disputed. There's no basis for a charge here. And it really can't conceivably be in the interest of justice that Mr. Zuma is now allowed to raise it again, retread the same territory. If we were going to argue all of these cases fully, we'd be here for 2 or 3 days, but it's all been argued, it's been decided. The court is with respect bound by the decisions of Kunje, the full bench and the SCA, and that's the end of that matter. That brings one then finally to Pillar 4. And it's difficult to know what to make of Pillar 4 because it is somewhat strangely formulated. Can I show your Lordship what Mr. Zuma says about it at page 46 in his founding affidavit? Paragraph 100. I'm sorry, my Lord. Paragraph 46, Mr. Zuma describes the fourth pillar, paragraph 100.4. He says, further and additional considerations which also have the effect of disqualifying Mr. Downer. And then you then go to page 70 of that affidavit, overprinted, paginated page 70, paragraph 160. He's now dealing with I'm sorry, my Lord.
Page again?
Paragraph, it's page 160. I beg your pardon, it's paragraph 160, page 70.
Yes.
This is now after Mr. Zuma has been talking about the spy tapes and browse mole and foreign agents and foreign spies and all of these things. He then says, paragraph 160, I am aware that some of these atmospheric issues have already been dealt with in previous litigation, albeit in pursuit of different causes of action. Whichever way they may have construed in such previous litigation, they are now invoked merely to demonstrate that the overall atmosphere is sufficiently poisoned and too toxic for any fair trial if Mr. Downer is or remains a prosecutor in the public prosecution brought by the state against me. And so they're not freestanding, this is not a freestanding ground of complaint. It just says, look at the context and look how toxic the context is. And Mr. Zuma says that himself. If you go to his replying affidavit, it's the replying affidavit, page 865. Paragraph 126. I beg your pardon. It's paragraph. Can I go? It's paragraph 865, paragraph 123 on page 865.
Oh, 123.
Yeah. In paragraph 123, Mr. Zuma says, it's not necessary to deal blow by blow with the issues raised under this catch-all fourth pillar of miscellaneous grounds, which I have raised mainly for revealing to this honourable court the broader context against which the three pillars relied upon me must be viewed. And then at page 1, and then he says that paragraph 124, he says, secondly, it ought to be clear that this honourable court is not being called upon to resolve the factually disputed incidents mentioned under this heading. Then on 2 pages later, on page 867, before I go there, 1 page later on page 866, paragraph 126. Mr. Zuma says the following: as specifically mentioned in my founding affidavit, these issues are not raised for adjudication. That's the fourth pillar. But to give this honourable court the atmosphere within which the present application takes place and to summon the court's empathy for the position in which I find myself. So they're not relied upon as a cause of action. And then over the page 867, paragraph 129, Mr. Zuma says, my case remains pivoted on the three pillars, as amplified and corroborated by the issues raised in the fourth pillar, which is not a standalone ground for recusal, but a supplementary or supporting ground. So that presumably explains why we haven't heard, your Lordship hasn't heard from our learned friends about the fourth pillar today, because it's not actually relied upon. It's just for, in Mr. Zuma's word, it's atmospheric. And your Lordship can make what he wants of that. I'm going to deal with two matters under this atmospheric pillar. I was also going to deal with the Glenister matter, but a learned friend is going to file a supplementary note, and we'll wait to see what he has to say, and then we'll respond to that. So the two matters on which I wish to deal, the first matter on which I wish to deal is a matter not raised by our learned friends in argument today, but it's a matter which is peppered throughout the papers by Mr. Zuma's affidavit and also in the heads of argument. They say, look here, Mr. Downer is not indispensable, so why not just remove him and replace him? And your Lordship will have seen that in the papers over and over again. And we say there are three answers to this argument. The first answer is the following: it's the wrong question. The question is not whether Mr. Downer is indispensable. The question is whether our system of the administration of justice allows an accused person to abuse the process of court and then use that abuse to require and request the dismissal of the prosecutor. That's the question. The question isn't why is Mr. Downer indispensable or is he indispensable. So we make the submission that if that is allowed, if our system of justice allows an accused person to dictate who may or may not prosecute him, because that's what's sought here, this is going to become a standard tool in the toolbox of well-resourced people who are facing serious charges. They will lay a charge, an unfounded charge, a trumped-up charge against the prosecutor. They will get a certificate nolle prosequi, and they will institute a private prosecution, and then we'll say the prosecutor must go. It will become a standard tool, and it will become a means of obstructing and delaying, and a means of preventing justice being done by getting the designated prosecutor, who presumably knows most about the case, getting rid of that person. And we submit that our law will not tolerate such a practice. The second issue is this, that besides that reason of principle, there are many practical reasons why the NPA wishes Mr. Downer to continue to conduct this prosecution. And this is explained at length in the answering affidavit. I'm not going to read through all of it, but I do want to show your Lordship the facts. And they are, again, undisputed facts. It's the answering affidavit, page 552. From paragraph 84, Mr. Downer explains what his role has been and is in this prosecution, and what the nature of the prosecution is.
That would be paragraph number?
552, paragraph 84. Answering affidavit.
Yes.
Mr. Downer says the following. The present matter is extraordinarily complex. It involves a docket and related material of many hundreds of thousands of pages, much of it electronic. Throughout this period, I have successfully coordinated, together with members of the team, all aspects of the case, which include identifying the initial indications of crimes, identifying relevant evidence of all kinds, be it witnesses or documents, studying all the evidence, directing the forensic accounting team and other forensic documentary experts, consulting with all relevant witnesses and other experts, consolidating the evidence into an indictment with reasonable prospects of success, preparing for the two trials of Sheikh and others and Zuma and Thales, and appearing in and advising counsel for the NPA regarding the countless applications for leave to appeal, reviews, representations, and other related litigation over the years, almost without exception, with success. Paragraph 86. In the light of all the above, the NPA has retained me to continue as lead prosecutor in this matter, even though he's retired, he's reached retirement age, he's been retained. I'm not sure how much he celebrates that at the moment. The NPA has retained me to continue as lead prosecutor in this matter because it regards my knowledge of all aspects of the case as more extensive and useful than any other prosecutor. Paragraph 87, the prosecution of the case would be severely prejudiced should the lead prosecutor, with my experience of years as the leader and with my record of success, be removed. 88, counsel for the accused are led by a team of senior counsel. I'm the only senior counsel in the prosecution team. It would be unfair and prejudicial to the interests of justice than the prosecution should the prosecution be derided as leading senior counsel and to be left with none. Paragraph 88, I led consultations with witnesses and the forensic teams in preparation for trial over a period of many months, in addition to the many months that had been spent similarly preparing for the Sheikh trial. Any prosecutor who were to replace me would have to spend equal time consulting, in addition to having to study the evidence in preparation for trial. This would inevitably mean another delay, coming at the end of a series of unacceptable delays over nearly 2 decades. The prejudice to the administration of justice would be severe. Paragraph 90, my removal, replacement and delays would cause severe financial prejudice to the NPA, the court and other parties in this matter, in addition to the financial prejudice all have already suffered by the decades-long delays, fruitless preparation for trial, and unnecessary costs in defending unsuccessful and unnecessary litigation of every kind, every sort, every time up to the highest courts. Mr. Zuma deals with this, responds to this. I'm not going to take your lordship there. It's a replying affidavit, page 855, paragraphs 76 to 78. He does not address or contradict any of the facts alleged by Mr. Downer, not one. All he does is repeat the assertion that Mr. Downer is not irreplaceable and not indispensable. So on the facts, there will be massive prejudice to the state, to the NPA and to the administration of justice if Mr. Downer is removed as a prosecutor.
So just a moment, please.
I beg your...
Just a moment, please.
No.
Yes, you may proceed, Mr. Butler.
So, my Lord, I've shown your lordship the reasons of principle why this argument of indispensability can't be accepted, and I've shown your lordship why, for the practical reasons why it can't be accepted, why Mr. Downer is needed. Then there's a third response to this indispensability argument, and the third is that the truth is that Mr. Downer's attack is not, Mr. Zuma's attack is not only on Mr. Downer. If Mr. Downer is removed, Mr. Zuma will then attack the participation of other members of the prosecution team. And that is what Mr. Zuma himself says. And then Trent can huff and puff, but that's what his client says. It's volume 1, founding affidavit, paragraph 159 on page 70. This is what Mr. Zuma says, paragraph 159. I therefore seek an order that Mr. Downer be removed and or recused from conducting my prosecution because he lacks the attributes of impartiality and independence which are necessary for the protection of my fair trial right. He must accordingly be removed as my prosecutor, and the NPA director to assign a new prosecutor who is untainted by the criminal violations set out in this affidavit. It is, in my opinion, also very doubtful whether the current members of the prosecution team who have been inextricably involved in the current legal prosecution would qualify. But that's not an issue which requires the adjudication of this court at the present moment. So we know what's coming. We know what's coming next. If Mr. Downer is removed and is next in charge, the next in line is substituted, there'll be another application to remove that person. And it'll come before your lordship, and your lordship will tell that that person too is complicit in these dastardly deeds which Mr. Downer allegedly committed. He's also a criminal, he's also an unethical person, and he must be removed as the prosecutor. So the attack is, he's given notice in that paragraph that if he gets rid of Mr. Downer, he's going to set his sights on the next one in line, and then the next one in line. It's an opportunity for a Stalingrad festival, my lord. It will be a festival of Stalingrad delay. Mr. Downer makes this point in his answering affidavit. Show this, your lordship, this. It's answering affidavit, page 621. And paragraph 199.2.
Paragraph 199.
199.2.
Yes.
This is what Mr. Downer, is your lordship with me?
Yes, I am.
This is what Mr. Downer says. He says it is clear that Mr. Zuma's strategy is to frustrate and delay his prosecution in its entirety by asserting that no one involved in the case is competent to prosecute him. He explicitly states that in his opinion no member of the current team qualifies to conduct the prosecution. Therefore, my removal alone will not satisfy his demands, as he will find reasons to complain about any appointed prosecutor who seeks to continue the prosecution. 9.4. It is evident that at the core of Mr. Zuma's grievances lies his belief that the entire NPA is tainted. Consequently, even if a new team were to be appointed, Mr. Zuma would persistently claim that the entire prosecution is marred by prosecutorial misconduct. Those are serious assertions, page 621. What is Mr. Zuma's answer? He doesn't address or challenge it. Your lordship, I'm not going to take your lordship there, it's the replying affidavit, page 865 to 6, paragraphs 123 and 126. So that's what's going on here. This is the first step in the preparation for a Stalingrad festival. Mr. Downer points out that in truth, Mr. Zuma's attack is directed at the NPA generally and not just him, although he's the focus. I'll just give your lordship the reference. I'm not going to take your lordship there. It's answering affidavit, answering affidavit, page 555, para 94.2, and page 556, paragraph 94.6. And we say that in his replying affidavit, Mr. Zuma doesn't attempt to address this. His replying affidavit, para 80 to 81. I don't have the page reference. I'll find it in a moment.
It's 856.
856, thank you. Para page 856, my lord. So, my lord, there are... Can I just check something before I continue and wind up?
He said today that the NPA is also criminal.
Yes. Mr. Downer reminds me that I learned from Mr. Mpofu said today, the NPA is criminal.
Sorry?
Mr. Downer, our learned friend, one of our learned friends said, I think it may have been Mr. Masuku, said the NPA is criminal. That's the attack. That's their position. So no one in the NPA can prosecute. The paragraph 29 of the SCA judgment, can I take your lordship there? As to what the SCA found in this regard.
Paragraph 29, Mr.
Paragraph 29, page 15 of the SCA judgment.
Yes.
The SCA says the following. Mr. Zuma's attacks are directed not only at Mr. Downer, but also at the NPA itself. Mr. Downer pointed out that Mr. Zuma has consistently attacked and questioned the credibility of the NPA as an institution. The harm to be avoided is thus not only to Mr. Downer personally, but also to him in his capacity as the prosecutor in Mr. Zuma's case, as well as to the state and to the administration of justice. So we say, my lord, there are three answers to Mr. Zuma's complaint argument that Mr. Downer is not indispensable. Firstly, it's the wrong question. Secondly, there will be massive prejudice to the prosecution and the NPA if Mr. Downer is removed. And thirdly, if Mr. Downer is removed, this will be the first step in a new phase of the Stalingrad defense, which will be an attack on other members of the prosecution there, and perhaps prosecution team, and perhaps on the NPA itself. Finally, my lord, I want to say something briefly about the question of the independence of prosecutors. As your lordship knows, there is a fundamental difference between issues of judicial bias and prosecutorial independence. When it comes to prosecutorial independence, the question is one of fairness. Will the accused get a fair trial from this prosecutor? We say that nothing that our learned friends have put up, or nothing that Mr. Zuma has put up, gives any reason to doubt that Mr. Downer will give them a fair trial. It's all about conduct. When one looks at Smythe versus Ushiwekunze, it was about the conduct of the prosecutor. He did this, he did that, he did the other, his brother was one of the complainants, etc., etc., etc. It's all about conduct. There's no conduct of any kind shown against Mr. Downer, which gives rise to think that he won't do the job professionally. The SCA has explained the test in the Porritt case, and I want to take your lordship there. In the Porritt case, and Porritt is much more important for present purposes than Smith decided by the Zimbabwe Supreme Court, or for that matter, Van der Westhuizen, because there the issue specifically was in Porritt was whether the prosecutor was biased, was not elect independence because he was being paid by the complainant, by SARS. And Mr. Porritt said, well, you can't have this. You can't have the prosecutor paid by the complainant. And this is what the court said, paragraph 11 of Porritt. Does your lordship have Porritt?
No, I don't have
It's in your bundle.
It's in our bundle, I think. Anyway, I'll just read your lordship what it says. Paragraph 11, there's a fundamental difference between the role and functions of a prosecutor as opposed to those of a magistrate or judge. The judiciary is held to the highest standards of independence and impartiality because they are the decision makers in an adversarial judicial system. Prosecutors neither make the final decision on whether to acquit or convict, nor on whether evidence is admissible. Their function is to place before a court what the prosecution considers to be credible evidence relevant to what is alleged to be a crime. And then the court says, paragraph 13, in adversarial criminal proceedings such as ours, it is inevitable that prosecutors will be partisan. They conduct the case for one of the two sides in a trial, namely the state, as representing the citizenry. They often carry out their prosecutorial functions vigorously and zealously. A prosecutor's role in a criminal prosecution therefore makes it inevitable that he or she would be perceived to be biased. Prosecutors usually approach criminal prosecutions with a view, sometimes a very strong view, that the accused persons are guilty. That is permissible, subject to the caveat that they must not prosecute in single-minded pursuit of conviction. Paragraph 14. The protection of an accused person therefore lies not in the general standard of independence and impartiality required of all prosecutors, but in the right to a fair trial, entrenched in Section 35(3) of the Constitution. Paragraph 16, your Lordship will read the judgment for himself, and it's not necessary for me to go through all of it in detail.
Page 255 to 256 of the bundle.
It's page 255 to 256 of the bundle, and I understand, my Lord. Thank you.
257.
257. And then, that I won't go there. We say that there is not a drop of evidence that Mr. Downer has acted outside the proper role of the prosecutor, with the result that Mr. Zuma's right to a fair trial has been prejudiced. The evidence shows that what Mr. Downer has done is he's conducted his duties with skill, professionally, fairly, vigorously, zealously, with persistence, and with dignity. That's what the evidence shows. That's what is expected of a prosecutor. He has done this in diligent compliance with his obligations. And it is true that when he learnt what some of his colleagues had done and were going to do, he burst into tears. And he explains why it was so. He explains that this was because his colleagues had betrayed their obligations and thereby betrayed also him who was carrying out his obligations. Nothing wrong with that. That doesn't make him a person who is unable to exercise a calm judgment and to run a prosecution properly. That's what it was about. And the truth is, as we know, that Mr. Downer, that the NPA, certain members of the NPA had in fact acted improperly and in breach of their obligations. And it's deeply ironic that a learned friend, Mr. Masuku, lays great emphasis on the findings of the court in the spy tapes cases as to how badly the NPA behaved. Precisely. Mr. Downer was the one who stood up to it, and he refused to be part of it. And I must show Your Lordship there's what was said by Justice Kun in that regard. Where's the passage? It's in the 106.1H, isn't it?
106.1H.
So there's a passage in the section 106.1H judgment, my Lord.
I've got the 106.1H here.
But I can't find it. But Your Lordship, we'll give Your Lordship the reference to it. What Justice Kun said was that Mr. Downer stood up against what was going on in the NPA.
Paragraph 243.
243 of 106.1H. Thank you. It's paragraph 243, my Lord.
Of course.
Find it somewhere. Right, it has got it. Thank you. Paragraph 243. Does Your Lordship have it?
448.
No, it's not 243.
448. It is 448 of your bundle.
448 of our bundle. Is this a 106.1H?
It is 243.
We're almost there, Mr. Putler.
Is Your Lordship with me?
Paragraph 243.
Paragraph 243.
The last sentence.
Yeah. Mr. Downer has explained, and here it is, that his insistence in 2003 that Mr. Zuma be prosecuted was based on his and the investigation and the prosecution team's assessment of the evidence against Mr. Zuma. Mr. Zuma's fair trial rights have not been infringed. Mr. Downer has consistently maintained that the decision by Mr. Mshe to institute criminal proceedings against Mr. Zuma should be implemented. He resisted the subsequent decision of Mr. Mshe and Mr. Hofmeyer to discontinue the prosecution. His stance was vindicated by the SCA. And there's a further passage where where the court refers to Mr. Downer's independence. It refers to what actually happened and demonstrates 215. Being very well fed with advice by my junior. Paragraph 215. It's at page 84 of the judgment. The previous page, 213 and 214, 213, Mr. Zuma's complaints are laid out. Paragraph 215, the court said, Mr. Downer was not an essential witness in the spy tapes case. He did not submit his affidavit in support of the DA. His affidavit was provided at the request of Mr. Hofmeyer after he, Mr. Downer, had refused to make an affidavit, simply confirming the contents of Mr. Hofmeyer's affidavit. The initial draft of Mr. Downer's affidavit was in fact revised by counsel for the NPA, Advocate Millard. Mr. Downer's affidavit disagreed with the decision of Messrs. Mshe, Hofmeyer, and the senior leadership of the NPA, who had sought to defend Mr. Mshe's decision to discontinue the prosecution. Mr. Downer's finalized affidavit was filed by the state attorney, which was representing the NPA, on 11 June 2015. These are matters of public record about which there is no dispute. Mr. Downer's independence of mind speaks for itself, and his stance was ultimately vindicated by the judgment in the spy tapes matter by the SCA, after both Mr. Zuma's counsel and counsel for the NPA conceded that Mr. Mshe's decision, which they initially sought to defend, was irrational and unlawful. So that's who you're dealing with here. The one man who put his hand up and said, no, you can't do this, it's unlawful, it's improper. And it is, with respect, deeply ironic that our learned friend, Mr. Masuku, should now seek to visit on Mr. Downer's head the misconduct of other members of the NPA against which he stood up to be counted. It's ironic in the extreme. So we say, as to fairness, there will... Finally, then, my Lord, we say the evidence, I've said already, the evidence shows how Mr. Downer has conducted his duties. Nothing which he has done has had the result that Mr. Zuma will not receive a fair trial. Nothing that he has done will have the result that Mr. Zuma will not have the day in court, which he has vigorously, which he used to proclaim he was looking forward to. He doesn't proclaim it quite so vigorously today. If and when Mr. Zuma gets his day in court, Mr. Downer should prosecute him, and he will be prosecuted fairly. There's nothing to suggest otherwise. So we ask, my Lord, that this application, which is arguably itself an abuse, should be dismissed. Thank you, my Lord. Okay. Can I hand up, my Lord, the judgment of Justice Kuhn in the recusal application, which I referred to? Thanks.
Right, who's next?
That's me, my Lord.
Do you want us to proceed or you want us to take an agenda?
We can take a short break, my Lord.
All right.
Actually, also need it.
Yeah,
That's good.
All right.
It's 10:05.
Can you adjourn till 2:45? How long are you going to be, Mr.? You've got
quarter past, you mean, my Lord? Quarter past. Not quarter. It's already 3:10. Oh, so it's 2:10. Yes, we can do quarter past, my Lord.
No. Well, how long are you going to be? By the way, how long are you going to be? Did you say 45? Another.
45.
You said 30.
45.
I think you said 30 to 45.
No, my Lord.
All right, then can you stand adjourned until 1:30 at least?
2:30.
2:30. All right. All right, we'll resume at 2:30.
Yes, God, please.
Quarter jams.
Your Lordship came before us.
No problem, Mr. President.
Thank you, my Lord. My Lord, if I may just, my learned friend, Mr. Badlander, forgot to hand up this. This is the ruling of Justice Kuhn
Yes.
that was referred to earlier.
I see.
And
Thank you.
I'll deal with it in due course, my Lord. My Lord, I just want to start by saying that my Lord, in everything, literally everything that Mr. Badlander has said, he has failed to address the question before this court. Even if you assume everything he has said is so, but what about the question, which is whether the applicant will be afforded a fair hearing in the event of the first respondent prosecuting the charges against him at the trial? We said in the morning, that's the only question before this court. It's not how good Mr. Downer is. It's not even whether or not he's guilty or not guilty of the charges in the private prosecution. Assume there was no private prosecution, my Lord. Assume, or even assume he had been acquitted in the private prosecution. That's not the question before this court. The question before this court is whether, facing the fact that he faces charges and is being prosecuted by Mr. Zuma, is not in itself inherently inimical to him playing the role of a prosecutor against the self-same Mr. Zuma. That's all. That's what we call Pillar 1. So it doesn't help us to go on about how innocent he is or he may be or whatever. That's just a waste of the court's time. And my Lord, let me link that to a very important legal question. Mr. Badlander says to the court, no, this court must, or rather, is bound by the findings of abuse of court and Stalingrad. That proposition, my Lord, is wrong at two fundamental levels. The first level is that it negates the reality. Imagine if our law was really what Mr. Badlander is saying. It would mean that while, according to the SCA itself, Mr. Downer is still facing a threat of a prosecution in terms of paragraph 21 of that judgment, the court must simply ignore that. And it must ignore the purpose of Section 18 of the Superior Courts Act and Section 34 of the Constitution. Yeah. Remember, my Lord, let's forget about the niceties. The purpose of Section 18 and Section 34 is to say you have to keep in your mind what if the appeal is successful? And that's the only question that must be asked. What if the appeal against the full court judgment is successful? Forget for now about the appeal against Section 18. The very court that said there is an abuse of court, which is 18, the full court. Yes. That is what is under appeal in the High Court, or rather in the SCA, and maybe in the Concord, depending on. Section 18 was meant to cater for that situation. That can we then say, what will happen if we allow Mr. Downer to prosecute Mr. Zuma, and then in the middle of that, the SCA finds that the full court was wrong. That's really what is the purpose of that. So in other words, we would have run a full trial for a year or whatever it is, only for the court to say, no, there was actually no abuse of court. The prosecution is all fine. In fact, it must continue. Let's just be realistic and not try to use legal technicalities. That is the mischief of Section 18. That's the first thing, my lord. But he is wrong legally. Because the principle of stare decisis, he is misapplying it. Stare decisis is a Latin term that simply means that the decisions of the higher court must be applied and settled matters should not be disturbed. But stare decisis does not apply to findings of fact. That's very important. Stare decisis applies to law, to findings of law or decisions of law. So, my lord, to make the ridiculous example, if the SCA says that for some reason it finds that Mr. Masuku and I is my brother, literally, he is my brother figuratively, but we can come here before this court and show that on the facts, here's the DNA, here's everything and so on, he's not my brother. The court cannot say, I am bound because the SCA said the sky is red. Even if I go outside and I see that it's blue, I'm bound. Facts do not bind the other court, right? It's the findings of law. So if the SCA, rightly or wrongly, said that Mr. Zuma spent 20 years running away from his trial, but were able to show this court, on the facts before this court, as we have already, for example, that 10 of those 20 years, so-called, were in relation to the spy tapes case in which Mr. Zuma and the NPA were on the same side. Can this court say, no, we're just going to close our eyes and ears to that? Because why? The SCA made that mistake or made that miscalculation. It doesn't work like that. If the SCA, and courts are human like all of us, if the SCA says now it's 2021, this court will be able to say, no, it's not 2021, it's 2023. Can't say it's bound by a factual finding. That's why stare decisis doesn't work the way that it is being presented here. But thirdly, paragraph 21, I've already made those submissions. Paragraph 21 makes it clear there's been no answer given, my lord, to assume the legalese about whether Section 18 can be appealed and so on are correct. There's been no answer to our proposition that even the SCA 2-3 weeks ago said that Mr. Downer, as we speak now, is staying under the threat of the prosecution. So let's put that aside. The second issue I want to address in reply, my lord, is that okay, let me do it like this. It's linked to the point that I made about the findings of another court. I'll give you a concrete example, my lord. If, let's say, Justice Kuhn says that, look, on the facts before me, I cannot find this or another. Then we come to this court 2 years later, after Justice Kuhn, and we present evidence on that which Justice Kuhn said, in front of me there's no evidence for ABC, whatever it is. How can we now be told that even if you now come with new evidence on this issue, because 10 years ago Justice Kuhn said he couldn't find anything, therefore you cannot do it? What kind of logic is that? I have presented to this court, and I did it, I'm indebted to the court and my learned friend, because I wanted to do it in chief so that we don't ambush my learned friend. We have given evidence that in this court, not before Judge Kuhn, in this court, Mr. Zuma says, the reason I went to the police station and laid the charges and started the law in motion for the private prosecution was because I received legal advice. That is not denied. That means it's common cause. Maybe that was not said before Justice Kuhn, but now it's said before you. It's common cause that the man received legal advice. He believes his legal advice. The lawyers might be wrong or whatever, but he believes them. And then he acts on that. And you want to tell me that he's acting malafide? Well, then it should be blamed on the lawyers, not on him. And it's common cause, this. It's not something that's disputed. So the fact that Justice Kuhn said this, that, or the other is completely irrelevant. And then, my Lord, let me put it this way. There are two factors, or four. There are four factors that they present for the so-called Stalingrad theory. One is that the matter has gone on for a long time. Common cause. They exaggerate and say it's 20 years, but we know it's not 20 years. Two, they say those cases were unsuccessful. Disputed, Mr. Masuku explained that some of the cases were successful before Nicholson J, before Het J, before Simang J, and so on. But let's put that aside. Let's say all the cases were unsuccessful. Since when is it Stalingrad to have a case that is unsuccessful? Surely it can be. For you to qualify, even on their distorted definition, there are two other things which must happen. One is that there must be bad faith. And two is that they say, I call it the relay. They say that we bring one case and then wait until the end and then start a new case. Your Lordship knows that that's what they say in the papers. I will show you very briefly, my Lord, that on those two elements, they are completely wrong. The first one is malafide, as we've dealt with. It's the lawyers, legal advice. The second one is the so-called relay. It's a blatant lie. This is what happened, my Lord. Mr. Zuma, okay, let me put it this way. For that to be true, the so-called relay, you would have had to, remember Justice Kuhn gave his judgment on the 26th of October, 2021. So that would mean then on the following day, once Mr. Zuma said, oh, I've lost against Judge Kuhn, let's start the relay. And then let's go and lay the charges. But on the objective facts, that is false. Because Mr. Zuma, long before Justice Kuhn gave the judgment, in fact, long before the matter was heard at all, said to this court on the affidavit in September 2021, I am going to lay charges against Mr. Downer. I was standing right here on the 21st of September. I said that to Justice Kuhn. I said, I've instructions from my client, who, by the way, on that day had waived his right to be present, the so-called Stalingrad. I said, I have instructions to do this. And that's why at paragraph 240 of Justice Kuhn's judgment, he says, if there is any complaint, sorry, my Lord. Contrary to this thing, we get fired that Justice Kuhn decided these issues. This is what he says. If it is believed that the provisions of Section 41(6) outlaws such conduct, then a formal charge in that regard can be pursued, where the proper application of Section 41(6) can be fully ventilated and its proper interpretation determined. That was because we had informed him. So how can it be said that we waited for this judgment and then started the next process. When in fact Mr. Zuma, even on the common cause facts, also went to the police station down the road, I don't know where it is, on the 21st of October, 5 days before the Kuhn judgment, and laid charges there. And yet we are told, no, he waited until the outcome of Justice Kuhn. So this whole Stalingrad theory is just based on smokes and mirrors. Firstly, on a non-existent 20 years theory, and secondly, on a non-existent relay theory. Even on their own definition, forget the definition given in Moyo and so on. On the definition of Mr. Downer himself, it doesn't work for them. Then, my Lord, if you go to Justice Kuhn's ruling, it is not true, my Lord, that Justice Kuhn did not deal with the same issues. We are at pains. We even put the pleadings to show that the Stalingrad theory was first invoked when we wanted to do a postponement on the 11th of April, 2022. I remember that date very well because it was the date before my client's birthday, 80th birthday. And we were here, we said we need a postponement for whatever reason. The other side came up with literally the same things they're pleading here. They said, no, it's Stalingrad, Statin, all these cases happened, And then we said, no, you can't. And Justice Kuhn rejected that Stalingrad theory. He said when he rejected it. The appeal, it's page 6 of what I've just headed up. The appeal process should be allowed to run its course. Mr. Zuma has challenged many decisions adverse to him in the past, usually invoking the entire appeal process to the highest court in the land, and in many instances has been unsuccessful, which resulted in inevitable and unfortunate delays. Common cause. Here's the important part. He says, he is also on record through previous counsel representing him that he will continue to exercise all rights available to him. But the exercise of those rights, as much as they may be viewed with suspicion and distrust from certain quarters, as resulting only in delays which only favor him, do not per se amount to an abuse of those rights. A finding of malafides would require more and clear proof by the state, which I cannot make on the allegations in the present papers alone. And I'm saying this, my Lord, with the conviction, every conviction I have. On the same basis now, you will find nothing new that has been alleged which suggests malafides. On the contrary, you now find something that suggests bona fides because he was acting under legal advice. Right. Then the next topic, my Lord, is misleading the court. My Lord, we can make our submissions and, and represent our clients. But what we're not allowed to do is to mislead the court. It was said that Mr. Zuma has said that, or rather, it is suggested that he has said that he will, any other prosecutor will object to that. Well, my Lord, that's wrong, and it's actually not borne out by the evidence. Mr. Zuma says to this court, this is under the so-called indispensability issue. He says, I have asked the National Prosecuting Authority and Mr. Downer that he must be replaced by another prosecutor. That's the same person who's saying he must be replaced is now accused of saying, he's saying that no other prosecutor will do. Mr. Zuma goes further. He says, I think it's page 70. And these words are distorted here in this courtroom. He says, I therefore seek an order that Mr. Downer be removed. I'm sorry, that's page 1, paragraph 159.
Of the founding affidavit.
70.
Okay.
Of the founding, yes,
The
Ballo.
founding, yes. Did you say paragraph 70?
70. Page 70. Madam.
Page 70.
Yes.
Paragraph 159.
159, yes.
Right.
And before I read this, I want your Lordship to tell me, or rather to look out for anywhere where Mr. Zuma suggests that any other prosecutor will not do, as was suggested here. He says, I therefore seek an order that Mr. Downer be removed and or recused from conducting my prosecution because he lacks the attributes of impartiality and independence which are necessary for the protection of my fair trial right. He must accordingly be removed as my prosecutor and the NPA be directed to assign a new prosecutor who is untainted by the criminal violations set out in this affidavit. Now, here's the important part where he's accused. He says, it is my opinion, also very doubtful whether the current members of the prosecution team who have been inextricably involved in the current legal prosecution would qualify, but that is not an issue which requires the adjudication of this court at the present moment. So I don't know how many members of the team, let's say there are 4 or 5. So Mr. Zuma says, if anything, this is an anti-Stalingrad stance, because he's saying, if you remove him, don't replace him, for example, with Mr. Breitenbach, because otherwise what Mr. Bartlander is saying will happen. Then there'll be another application. And don't replace him with these 4 or 5 people who are tainted. Replace him with somebody else.
Who is not tainted.
Yes, who's untainted. So the NPA has got, I don't know the number, 1,000 other prosecutors. So he's saying, don't do this 5, do the other 995. So that we can get on with the trial. And then he gets accused now to say, no, what he's saying there is that any prosecutor will be challenged. That's just complete misleading. If you look, my lord, at I think it's page 867. No, it's 621. Sorry, my lord. 621. Then this is now distorted by Mr. Downer. He says at 199.4. 199.3, he explicitly states that in his opinion, no member of the current team qualifies to conduct the prosecution. True. Therefore, my removal alone will not satisfy his demands, as he will find reasons to complain about any appointed prosecutors who seek to continue. It is evident that at the core of Mr. Zuma's grievance lies the belief that the entire NPA is tainted. Where does that come from? The man has put under oath to say the members of the entire team, 4 or 5 people. Now suddenly it's grown to all 1,000. It's then said that, well, for the first time it's considered that certain people in the NPA acted in a criminal manner, which is correct, by the way. That should be common cause. And in fairness to Mr. Downer, it must be said that when Mr. Mshe, I think, was doing his announcement, they insisted that a distinction must be made between the prosecuting team and the leadership that might have done certain criminal things. But the point we make, and there's a point Mr. Masuku, I know, feels very strongly about, and he mentioned it this morning, is that what you then expect from an impartial prosecutor is some acknowledgement by Mr. Downer, as I say, at least it was done through his counsel now, that certain things went wrong, that it was wrong to discuss about whether the charges should come before Pulukwane or not Pulukwane with Mr. Ncuka, who was not even working for the NPA at that stage. He must accept that. He must accept that that was criminal behavior on both the parts of Mr. McCarthy and Mr. Ncuka. I'm not saying Mr. Downer was party to that. In fact, according to the evidence, he says he was not. But he must accept that. He must also accept, my lord, that it was wrong. Whether it's criminal or not is not of the moment now. It was wrong for him to have a conversation with Mr. Soul. And I'm sorry, my lord. It starts at 693, my lord. Which we would not have known about, by the way, if the so-called spy tapes had not leaked. He can't, my lord, he can't just want to, the court cannot be expected really to believe something which is, where we say, it's here in front of you. No, and you are told, no, all he did here was to explain how the procedure works. But the court has got the transcript. And in the transcript at 692, this is the way he says he was the spokesperson, as Mr. Masuku said, if anyone believes that. And remember, this is the language of someone who thinks they're never going to be caught out. Mr. Soul says, yeah, DOJ has a spanner in the works. And then Mr. Downer says, everyone knows about the MLA applications. They are sitting on it and haven't done anything. Right? Let's just stop there. And that he says he didn't give any information. Remember section 416, my lord, and this is another red herring. We're told that he says, I never gave Mr. Soul any confidential information. That's his defense. But that's a calculated rewriting of the law. There is nothing in section 416 that talks about confidentiality. They rewrite the law to create a defense. Section 416 says you must not give any information, whether it's confidential or not. So here he gives information. Everyone knows about the MLA application. They're sitting on it and haven't done anything. What has been sent back with, why has it been sent back with queries? Clearly, process is triggered by application is twofold. We help them and they inform us about the crime. In respect of the process, DOJ has done F all. I can't read it in court. In respect of the process, the DOJ has done F all. And we are told there's a spokesperson of an organ of state speaking in that kind of language. And in the next one, Mr. Soul says, but I know I don't want to get you into S, for another four-letter word. But we know it was confirmed by Charlie's record that a formal investigation is underway. Then, and then here's the killer. I'm still at page 693. He says, BAE, new investigation has to be declared, new terms have to be assigned, and so on and so on. Then he says, but you can't quote me to say that. No, I'm not going to quote you, says Mr. Soul. Then jump, my lord, to page 696 at the bottom. And let's see if this is the behavior of someone who is officially doing his job. They are now discussing the article. He says, when you say, this is Mr. Downer, when you say senior NPA official are going to be angry, in the article, I suppose, who's that? And then Mr. Soul says, oh, well, in other words, he's saying, well, you know, it's you. Yeah. Then he says, I don't want any of those things to come from me. Some of the things seem to be first-hand information. It must not come from me. They will ask who's talking to the MNG. They, the people that he says authorized him. He says they will ask who's talking to the MNG. and we are told that all this is innocent. Please, really, I think there's a level at which we must be respected. So, my Lord, there are many of these examples, and then we are also told that we did not dispute. It's 856. Sorry, my Lord. Yes. The Lordship will remember the exchange Mr. Padlander referred to regarding, you'll find it at paragraph 80 onwards. These are the issues about Mr. Downer's participation in the investigation, and then yes, and the section 35 rights. Anyway, it's paragraph 80 to 93.
Which affidavit?
I'm sorry, my Lord,
Yeah.
of the founding affidavit, yeah. But, my Lord, the things that this is the issue, my Lord, to do with Mr. Downer's indispensability.
I see.
Yes. It said that we did not dispute all those things that Mr. Padlander listed, why he's the only person in the world who can prosecute. But this is not true, my Lord. We said at paragraph 78 at 856, in any event, I'm advised that it will be argued that it is false and self-serving proposition, to say the least, that in the unfortunate event of something happening to Mr. Downer, which would render him incapable of proceedings with his role as prosecutor, that would necessarily spell the end of the prosecution. So Mr. Zuma is saying once again, that Mr. Downer is not indispensable. And Mr. Zuma has got very many reasons to say that, my Lord. Imagine if Mr. Zuma were to say that in this court. He would be laughed off. If he said to you, my Lord, or any court, you know, I started this case with Mr. Kemp, and he's so steeped in this matter, and you know, he's done this, he's spoken to 100 witnesses and so on. And now Mr. Kemp, unfortunately, has left us. Therefore, my Lord, you must let me go now. Anybody would say that, what's wrong with Mr. Zuma? Because there are many other counsel who can take over the case, as we have all done. And none of us is indispensable, much as we would like to believe that. So that's what he's saying. He says it's wrong to say that the prosecution, of course the prosecution will be delayed. Of course someone else will have to read the papers like we all did. We all had to come into this case and read everything since the case started. It has never killed anybody. And then he says, as it happens, Mr. Downer is legally incompetent to continue with the prosecution due to having retired from the NPA approximately 2 years ago. I'm advised that further legal argument will be advanced regarding the falsity of the theory of Mr. Downer's self-proclaimed indispensability. Save as aforesaid, I deny the remaining allegations. In other words, he denies all those allegations. Of course, he cannot deny the fact that Mr. Downer has been involved in the case for so many years. That's not the issue. The issue is whether he's indispensable or not. My Lord, what they are really saying is this. It's actually, one cannot even believe they can say this. What they're saying is that Mr. Downer has been so much involved in this case that we can go out of this room here and Mr. Downer can take out a knife and stab Mr. Zuma. And Mr. Zuma must do nothing. He can't come to the court and say, no, Mr. Downer stepped me outside, therefore I don't want him as my prosecutor. They say, no, but he has spoken to all the witnesses and so on. So he must continue, irrespective, whatever he has done. He can take a machine gun and shoot outside there. And what is that? Surely the law says that there is a point at which the conduct of the prosecutor must be such that they must be removed, irrespective of that they've been in the case for 1,000 years. It doesn't matter. But the interest of justice that they are invoking in the fact that someone else will have to read the papers against the interest of justice of Mr. Zuma to a fair trial, which one must triumph? We must just carry on because Mr. Downer is indispensable. And much as I regret, I don't like saying this, what if we say this in somewhere in the papers, if Mr. Downer is hit by the proverbial bus, God forbid, tomorrow as he leaves the court here, is that going to be the end of the case? Well, if it is, then we will be happy to know that. But we suspect not, because of course the NPA will find another prosecutor to prosecute the matter. So the Downer indispensability theory is just a self-serving ego trip about his own self-image of indispensability. None of us are indispensable. Anyone can be replaced, especially if justice demands that. Yes, as Malene Jr. mentions, yeah, Mr. Trenkov was replaced by Mr. Badlander. And and the sky did not fall yet. In fact, to the credit of Mr. Badlander, he's done a great and probably a better job. So, trying to get my learned friend to give up his aeroplane seat for me later. My Lord, I don't have to belabor that point. No, there's no counsel in this country who's irreplaceable, even Mr. Badlander. Then, my Lord, I've already made this point, but I'll just make it quickly in passing. I've said this. I said this at the SCA one day. There's nobody who has been more misrepresented than Justice Kuhn. Poor Justice Kuhn. Everybody abuses what he said and twists it and misrepresents it. I've already referred your Lordship to paragraph 240, where Justice Kuhn says, I cannot decide this issue about section 41.6 because he says, this complaint was only made in argument, and then in reply, Mr. Downer did not have the opportunity to respond thereto, and so on. And then he says, I won't deal with it. And then he says, these are simply ruminations without the benefit of having heard considered arguments. But the ruminations are now elevated to findings, of immutable findings.
Of fact.
Yes, of fact and law and everything. It's God's, it's the 12 tables. Now, and then again, Mr. Badlander says to your Lordship that Mr. Downer, Mr. Justice Kuhn, found that there was the rights of privacy of Mr. Zuma were not an issue. And he reads at section 266. But again, Justice Kuhn said the following: these are all considerations which a court will still have to consider once fully ventilated and after all medical reports relating to Mr. Zuma's treatment, medical parole, and the like have been produced, should the medical condition of Mr. Zuma be or remain a material issue of determination in further legal proceedings. Now, we are in such further legal proceedings, but we are told, no, you must listen to Justice Kuhn. Then he says, I'm not persuaded that the disclosure of the contents of the letter constituted an actionable violation of Mr. Zuma's rights. He says that. But in the very next paragraph, which is not read to you, he says, in the alternative, if it did, in other words, if Mr. Zuma's rights were violated, then Mr. Zuma would have remedies he might pursue. He's doing that now, and now he's being stopped. In the context of the prosecution of Mr. Downer's title to prosecute, it might be at best to amount to an irregularity. Let's stop there. The often quoted Mr. Justice Kuhn says at best what Mr. Downer is being accused of at best amounts to an irregularity. So that's what we say. For the purposes of these proceedings, that would be enough. If he committed such an irregularity, says it bears repeating as held in shake that while some irregularities may result in a failure of justice and an unfair trial, not every irregularity has that effect. The question is therefore whether, even assuming that it amounted to any irregularity, whether it was of a kind to render the trial unfair. And he says, I'm not persuaded on the evidence that has been placed before me, in his case, not before you, my lord. That Mr. Downer has therefore been deprived of the title to prosecute and or should be removed as prosecutor. The merits of the prosecution stand apart from the events concerning Mr. Zuma's medical condition. So what Justice Kuhn was saying is that for the purposes of Section 102(1)H, I'm not convinced that all this amounts to a lack of title to prosecute. Non-constant that he was saying, forever, amen, these things can never be invoked in another proceedings. In fact, you are saying the opposite, that in those other proceedings it should be invoked. Then again, my lord, the last of these references. Mr. Badlander reads the SCA judgment, which paragraph 10, Ponan J.A.'s judgment, my lord.
Yes.
As usual, some of these things are important for what is not read than what is read. So Mr. Badlander read the first sentence, which says, what emerges is that the central purpose of the private prosecution is to enable Mr. Zuma to have Mr. Downer removed as the prosecutor on the basis that he stands accused in the private prosecution. Then he jumped to paragraph 11. But let me read what he did not read out. This is what the SCA said. However, the question of whether Mr. Downer should be removed as prosecutor is of course not before this court. Mr. Zuma's second attempt following upon the failed attempt before Kun J to achieve this is pending before Chili J. Ultimately, whether Mr. Downer is prosecuted depends on the successful outcome of Mr. Zuma's appeal in the main judgment. There are two propositions that are made there. The SCA is acknowledging that it cannot be pronouncing on what is before your lordship for obvious reasons, not even just judicial committee, because it would be wrong to do so. It's acknowledging, it's saying this issue of the removal is before Chili J, it will be decided there. And the second thing it says, which is the same as paragraph 25, is ultimately whether Mr. Downer is prosecuted depends on the successful outcome of Mr. Zuma's appeal in the main judgment. And this, my lord, must not be confused with the appeal on the section 18. It means that pending the appeal in the main judgment, which is now before the SCA court, the prosecution may still proceed. So those are the passages that actually work in our favor, even if one accepts the argument of the. And my lord, with the greatest respect, let me not even entertain that, because I'll be wasting the court's time. But for the record, let me say that we do not accept the proposition that this judgment of the SCA is not appealable. And whatever the SCA might have had to say about it, we will contest that in the Constitutional Court. But that's not important, my lord, because your lordship can assume, you can see that I've also relied on that judgment. Assume that that judgment is not appealable. Then it does not assist the other side, my lord, in its own terms, anyway. And in any event, no one can deny that there is still the main appeal. We can ask it like this, my lord, in a rhetorical fashion. If indeed the judgment of the High Court, of the full court, is extant, then why are we all wasting our time waiting for the appeal in the main judgment? Because the outcome of that will determine, as Justice Ponan said, whether the prosecution proceeds or not. Then the other proposition, which is wrong in law.
But actually what is being said here is ultimately whether Mr. Downer is prosecuted depends on the successful outcome.
Of course. Yes, yeah. No, I'm happy with that, my lord. On the success, in other words, on the reversal of the full court. Yeah. Yeah. Yes, no, fair enough. We say the same thing, my lord. And that's what is also said in paragraph 21, that they are still under the threat. That word threat is used advisedly. The threat of prosecution, because of course they could win even in that court, and then the threat will be removed. But for now, the threat has not been removed. Then, my lord, my learned friend makes a fundamental mistake of law because he misreads what Justice Ponan was saying. Sorry, I can't remember the paragraph. Oh, yes. Well, let me just say this. Even Justice Ponan or anyone cannot change the law as it is. So if my learned friend's proposition is that, and I think it is, and he'll correct me if I'm wrong, I'll allow him to correct me.
No, I don't think he still has.
Yes. If his proposition is this, and I know I'm right because he made the same, no, actually it was not him, it was Mr. Ngaitu. The same proposition was made in the SCA. There's this new thing that says what is suspended is the order, but the reasoning survives. That is meant to facilitate the following. To say, okay, the order might be under appeal, but the fact that it's found, the conduct of Mr. Zuma is found to be Stalingrad, abusive, and what have you, must survive. Well, that's such an artificial misrepresentation of our law that it should never be countenanced. And I will show you why, my lord. Look at section 18 of the Superior Courts Act.
Superior Courts Act,
yes. The heading of that section alone gives it away. It's called the suspension of a decision pending appeal, not suspension of an order. In law, it's right, my lord, that a decision means the order and the judgment. And the court says, subject to subsection 2 and 3, and unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision, which is the subject of an application for leave to appeal or an appeal, is suspended pending the decision of the application or appeal. In case anyone thinks that the legislature was asleep, go to 18.4. 18.4, Roman 4. This is now in respect of an 18.4 appeal, my lord. There it says, if a court orders otherwise as contemplated in the subsection, there'll be an automatic appeal and so on and so on. And then it says, such order will be automatically suspended pending the outcome of the appeal. So the legislature knew the difference between a decision and an order. And what is suspended is the decision, or the whole thing, including the finding on abuse and what have you. That is what will be determined in the ultimate court. And that is what causes the threat of a prosecution. But my lord, in any event, what we have said to your lordship, we are not here to talk about the conviction of Mr. Downer. It would be wrong to do that. It would be unfair, actually, on your lordship, because that will be determined after witnesses have been led and all sorts of things, cross-examined. Yeah. So this court is not supposed to, is not being asked, just as in Smith or Smythe, my lord. We've illustrated, in Smythe, there was no question of that prosecutor being prosecuted for anything. All that was looked at was his conduct, and he was recused on the basis of that. So it's not necessary that there must be a criminal prosecution, let alone a successful one.
Right, wrap up now, Mr.
Yes, I will, my lord, I will. Sorry, my lord, let me just check my notes. I know this. Okay, I've made the stare decisis point, my lord. Oh yes, my lord, I've made the point that the confidentiality, the adjective confidential is one that is sneaked by them. And it's not a requirement of the law. My lord, let me just make this point, and again, Mr. Butlander will forgive me because I've made it before. Let's take away all the legalese, and let's just think, my lord, what is really at stake here? Why did our legislature put such a law as Section 41(6)? The legislature said, my lord, if anybody working for the prosecution discloses any information that has come to his or her attention in the course of their duties without the permission of the NDPP, that person must go to jail for 15 years. 15, not 15 months. Yes, exactly. 15 years, my lord. Plus a fine in case there's a problem. It says 15 years plus a fine, or both.
Or both.
Yes. That's how serious it is. Just to give you perspective.
15 years or a fine, or both.
Yeah, that's how serious it is. So you could go to jail for 15 years for doing what Mr. Downer did, or be fined 100,000 rand, or both. That's how serious our law thinks this thing is. And here now it's being trivialized. Oh no, he only did this at such and such a time. No. To disclose any information, confidential or otherwise, without the permission of the NDPP can land you in jail for 15 years. To give you perspective, my lord, something closer to home, how serious this is. Mr. Sheikh, who of S versus Sheikh, was accused of a catalogue of corruption, theft, and what have you, was sentenced to 15 years without a fine. So that's how seriously our law looks at the crime in question. And why, my lord? Everyone looking at it would say, no, this is just disproportionate. Surely the person should go to jail for 6 months or a year or whatever, or just be slapped with a fine, to give an example to other prosecutors. No. The legislature deliberately put this hefty sentence, which is heavier than even murder sometimes. Why? To preserve the integrity of the justice system. Because if we have prosecutors who do what Mr. Downer has done, who go around deep-throating and phoning journalists and WhatsApping them documents about accused persons, what is going to happen to our justice system? What can we even have something called a justice system? If Mr. Downer says, and my learned friends can giggle about it, but the legislature did not find it as a very funny or as a giggling matter. It said you must go to jail for 15 years. And if you phone Mr. Soul and do what you did, or if you call Ms. Karen Mon and do what you did, or if you know about it and do nothing as far as the ethical standards are concerned. So that's very important, my lord, for perspective of what it is we're dealing with here. It's not as if Mr. Zuma just woke up and said, oh, well, which is what we're told now. We're told that all accused will do this. They'll just wake up and say, no, I'm charging the prosecutor, and I want an only prosecutor certificate. As if it's Mr. Zuma who said they must phone Ms. Mon. It's not. They did it on their own accord. So what must happen? He must say, no, I'm not going to do anything. I'm going to be violated. My medical information can be branded everywhere because I'm worried that other accused will do that. If they didn't want Mr. Zuma to go to the police station, they should not have leaked his medical information. That's all. You can't blame the victim. You can't. You can't blame the very person whose rights they've violated and say that, well, he must, develop a thick skin and move on. No, we're not going to move on. The law must take its course. And last point, my Lord. Yes. Mr. Masuku, poor Mr. Masuku, just like Justice Kuhn, is also being accused of things. Mr. Masuku says that there were criminal activities, and as I said, my Lord, the criminal activities have been acknowledged. But again, my Lord, let me give a broad brush submission. We go to the NPA. We say to them, remove this person because of this and that. They say no. We appeal to his own conscience. He says no. He's still sitting here now. And we point out that there are these now admitted criminal activities back home or upstairs or whatever. I don't know how the NPA works. So all Mr. Masuku is saying is that even though against our own interest, we are saying that please find another prosecutor who can prosecute this. But do not be blind to the fact that the NPA, as far as this is concerned, is itself is a crime scene. It's a crime scene because of any, and I'm saying this, my Lord, with the seriousness it deserves, any National Director of Public Prosecution or deputy who can tolerate the fact that an accused person, however much you hate him, must be prosecuted by somebody who has done the things that we have gone through here, and says, no, it's fine. Not only it's fine, and I will pay for his defense in the private prosecution, and I will pay for his defense in this application, and I will issue a statement as was done. As soon as Mr. Zuma went to the police station, they issued a statement. It's in the papers, my Lord. They said, Mr. Downer is the best. We don't know what these people are talking about. These are the same people who are expected, once the police have done their investigation, to look at the document objectively and decide whether to prosecute or not. But before they even see the complaint statement in the police station, just by hearing that Mr. Zuma has walked into a police station, they issue a statement to say, Mr. Downer is innocent. That's what we're dealing with here, my Lord. And if we're going to have a country like that, then we must kiss this democracy goodbye. Because the rights enshrined in the Constitution, including the rights to privacy, including the rights to dignity, including the rights to a fair trial, including the rights to a fair hearing, including the rights which come from Section 179(4) to be prosecuted by an impartial prosecutor, also reside in Mr. Zuma. He's no less of a citizen than anyone else. Those who don't like him must just deal with it, but they must understand that he also deserves the justice, and he will not get justice until the day Mr. Downer is removed from this trial. As the court pleases, let me just check it. My Lord, the point which the references to the stay of prosecution cases which I made earlier, there was no response to that, so I won't go to that as well. Again, simply to say that if this court, now this one is really binding on you, my Lord, unlike all these other things that we have been told are binding on you. If this court, the full court of this
Division.
case,
Oh.
a full court of 3, said that 10 of the years that of the delay were the joint responsibility of the NPA and Mr. Zuma. But you are now asked to believe the opposite. Why? Because the SCA said so, as a question, as a matter of fact. So your Lordship must. There's been no answer to that proposition. There can be, because it's true. But your Lordship should close his eyes and ears and say, no, it is 20 years of Stalingrad. I don't care, because Justice Ponan bought into that. Well, I can tell you, my Lord, Justice Ponan bought into that because it was in the full court judgment, that the so-called 20 years theory. And that is exactly what is before the SCA in the main judgment, which may or may not be reversed. As the court pleases, my Lord. We are indebted to your Lordship, and
yes, no problem. Yes,
those are our submissions.
Thank you. Yes, gentlemen, I'm sure you do realize the fact that you have given me so much to think about, and I have to reserve judgment. So judgment is reserved.
As the court pleases.
Yes, but can we deal with another elephant in the room, please? An issue pertaining to the private prosecution that was set down for the first.
Yes. Yes. Well, my Lord, since your Lordship is here, I can only say this, that there's been some exchange of correspondence with the JP, and I stand corrected, but I think your Lordship was copied in that correspondence.
Yes.
My Lord, as far as we are concerned, we are awaiting the response of the JP, and I suppose your Lordship is in the same boat.
Yes, sure, but shouldn't we simply remove that matter from the roll for now, given the fact that there's been a lot of
litigation?
Yes.
Well, my Lord, let me put it this way. I hear what your Lordship. I won't give a direct answer because we need to get instructions.
All right.
Let me just maybe appraise your Lordship as to what our instructions are up to now.
Yeah.
Our instructions, my Lord, remember that's about the appearance itself.
Yes.
Yes, our instructions, my Lord, are very simple, and they are that.
Let's see whether we'll be able to reach an amicable solution.
Yes, no. In fact, that's what I should say. Between now and the response of the JP, my Lord, right, there might be some tete-a-tete.
Yeah.
But putting that aside, our position is this, my Lord. And our position, by the way, is fashioned by the attitude of the state. You remember, I just referred you to the judgment of Justice Kuhn.
Yes.
These were situations where, my Lord, our client was incarcerated, he was in hospital, and so on. And he was required to be here. The 20 years that they talk about, even if it's exaggerated, Mr. Zuma has never failed to be here, whether he's sick or not. In fact, one time when he was sick, a warrant of arrest was issued. So he's saying, why should there be special treatment for other accused persons? Why? What's the difference between them? Is it because he's black? He says all accused persons must be treated the same. So if they were told here by your Lordship, no less, to say, be here at 9:30 on the 1st of November, otherwise you'll be arrested, then why must they not come here and explain? It's so, and your Lordship, I must say, I accept what your Lordship is asking now, because by coincidence, your Lordship is the judge in that matter as well.
Yes.
Assume it was another judge, and that judge said, come here on the 1st, and then he reads in the newspaper that, no, there's been some arrangement, they're no longer coming. When there's a court order, the proper thing to do, my Lord, apart from a settlement, as your Lordship has said,
yes,
I'm putting that aside for a minute. The proper thing to do is we would have to come before that court, as we've always done, and explain to that court, this is what has happened, the SCA has done this, and so on and so on. Therefore, the matter may be removed from the roll, subject to this and that conditions. And there'll be a court order. And I'll explain now why a court order is important. It can't just be done informally. And then that's it, my lord. Then, in fact, we have a case like that now in Johannesburg, the case of Mr. Ramaphosa. He went to court, he asked for an interdict. That's what they should be doing, not try to take shortcuts. Ask for an interdict if they don't want to appear. And then the case then continues in his absence because he has a court order. And so that's what should happen. Everyone knows that that's what should happen, putting aside any arrangement that might be reached. The second thing, my lord, which we have invoked, is to say Section 11(1) of the Criminal Procedure Act says that if on the prescribed date, the one prescribed by your lordship,
Yes.
the private prosecutor does not appear, the case will be dismissed. Remember, in the civil courts, if you are not there, it's just struck off the roll. You can come back but the legislature saw it, it said if the private prosecutor is not there, the matter will be dismissed. In other words, that will be the end. All these appeals will be irrelevant because the private. So why must Mr. Zuma put himself in jeopardy of the matter being dismissed because of that, except if there was a court order? And the court order, my lord, if we do succeed in settling the matter, will read something like this, for example. Subject to the outcome of all appeals, what have you, in the main application, one, the matter is postponed sine die. Your lordship knows in terms of Section 168 of the Criminal Procedure Act that the courts don't easily postpone a matter sine die. Yes. But there are exceptions. Let's say that's what the parties will agree. Number two, during that period, the operation of Section 11(1) will not prejudice Mr. Zuma, so that he gets his protection.
Just a moment.
And so on. So those are the kinds of issues, my lord. But subject to any agreement around those things, the law must apply as it applies to Mr. Zuma and all the other millions of accused persons. If you have been warned to appear in a court on pain of being arrested, even if you are in Cuba, as Mr. Zuma was once, and Judge Billy here said, no, I'm not interested. A warrant for his arrest. So that's it, my lord. Otherwise, the law is going to must not have eyes and see color and see all these things. But we hear what your lordship is saying,
yes,
and we'll consider it. Because, of course, we all have to be sensitive to judicial resources,
yes,
and all that.
Oh, that's fine. Thank you.
I would assume that your lordship would allow me to say something on this issue from the state side. First of all, whether the matter should be removed from the roll. As my learned friend says, we have written to the JP and to your lordship, on copy to all the parties, so we're waiting for the answer. And in that, we ask that the matter be removed from the roll. I must say that so that we don't appear. And that is so because, my lord...
I'm sorry, my lord, I have to object to this.
Because he's being represented.
Well, first he's being represented, but he's an accused in the matter we're talking about. He's the accused number one. We can't be listening to him now.
I've got the point. Yes. At least if the attorney was... Who is the attorney?
Yeah, the state attorney. He's not
state
the
attorney. Who is the state attorney?
If your lordship would prefer Mr. Butler to do it, he can do it.
Yes, Mr. Patland.
Thank you.
It appears to me that.
Either Mr. Patland or the state attorney, because we've got a letter from the state attorney.
Madam Lord, as I understand it, my learned friend, Mr. Mpofu, accepts that the matter can be removed from the roll. The only question is whether it should be done today or it should be done on the 1st of November. We say that the sensible thing is to do it today. Everybody is here. There's a waste of time and costs and travel expenses. Mr. Zuma, Mr. Downer has to come from Cape Town. Ms. Moore has to come from Johannesburg. And the court's time. We suggest that the matter should be removed from the roll today by order of court, as my learned friend suggests. The court can say that the matter is postponed sine die. It is removed from the roll for the 1st of November, and all of this is without prejudice to Mr. Zuma's rights under Section 11 of the Criminal Procedure Act. And then everybody is satisfied, and there's not a waste of time and money and effort in a really futile argument about whether the removal from the roll should be for today or for tomorrow. I have to, or the 1st of November, I have to respond to the suggestion that this is a racial issue. Mr. Zuma himself has been excused from appearance many times in this case, I'm instructed, and he wasn't required to be here today either. And the French, the French aren't here at all. Well, they're not required to be here. They choose to be here. And what do they call talias? So that's, to try to rationalise the issue with respect is unhelpful.
Right. Where do you go from here, Mr. Mpofu?
My Lord, I have a proposal. My Lord, I want to respond to the last remarks. Your Lordship, I think, understood what I was saying, that I'm asking a rhetorical question. Why is it that Mr. Zuma must be expected to come here day in, day out? He also has to travel from his home. He is. He's always required to be here.
You're excused today. Mr. Zuma is excused.
No, I'm not talking about today. I'm talking about the so-called 20 years.
I'm still presiding.
I'm sorry, my Lord.
I'm still presiding.
I'm sorry, my Lord. I should not have responded to those unsavory remarks. My Lord, I'm not talking about today. I'm not talking about yesterday. I'm talking about everyone in this country has seen Mr. Zuma coming to this court in and out for every little procedure. And when we said the matter must be postponed sine die, Mr. Downer, nobody else, stood up here and said we are engaging in Stalingrad until Mr. Justice Kuhn put a stop to it. So he's the last one to lecture us on if Mr. Zuma, through the kindness of his heart, is inclined to consider this proposal, my Lord, then I have said that, Your Lordship, I could not have anticipated this. I've explained what my instructions are up to now. But surely I must be given an opportunity to consult with my client.
Yeah. It's understandable.
And yes, my long-suffering client must be able to say whether he wants to extend that olive branch. And if he does, my Lord, the first is next week. We will, in the exchange and in our discussions with our learned friends, come to that. And I think that was the spirit in which Your Lordship was raising the matter.
Yes.
But not putting a gun on our head to make a decision without consultation. So that's all there is to it, my Lord. And but whether Mr. Zuma will grant that olive branch, knowing him, he probably will, or not, the point must never be forgotten that there are no special accused in this country. Everyone must come here and stand there in the dock like all of us, whether they are tall or short or black or white. I'm saying that again. There's no special dispensation. An accused person is an accused person, whoever they are, however much money they are. If Mr. Zuma, a former president of this country, comes here, then everyone should be expected to come here.
Right, I'll wait to hear from you then in due course. Right. Yes. We are adjourned.